possible, Millard, supplement?
Let him complete first.
Millard.
Yes.
Today is the last date. If it is
Tomorrow
possible,
it will be listed.
Millard.
May I have my lords,
Lordship, the extension of interim order which passed on the and expired on 28th June. Lordship. Extension of interim order which is expired on 28th June 2024. Lordship. Two matters.
Extension.
Interim order.
Extension.
The urgency is already explained, my lord. The urgency is also recorded in the last order also. It is very urgent for us to get this matter disposed of. We are trying to get this matter disposed for a long time.
How can this be taken up in
Last Friday we mentioned your lordship.
There are 2 days left.
On the last,
be
All
heard.
the pleadings are complete, my lord. Only due for final hearing. Nothing more about.
How can it be taken up? I don't understand. It can be listed. You give it.
we have to submit lordship that on last Friday, on last Friday we
my lord,
mentioned,
may I have my lords kindly to
your
mention
lordship
an
was told
extremely
that,
urgent.
your lordship last Friday told to us that to mention on today only,
Which matter I know.
this matter, this analogous matter.
We mentioned the second half, your lordship was pleased to.
I'm listing the matter, but I don't know whether I can take it up or not because there are also other matters.
My lord, under
matter for execution, we have already filed stay application. We have to praise that stay application is already execution has been filed. With some priority, your lordship.
Stay. Application list will
The extension of interim order.
extension of interim.
my lord, may I have my lords kindly to mention our matter, my lord, under compelling circumstances. My lord, the second appeal is going to be executed, the decree is going to be executed on the 26th. So, the lordship kindly directs the matter to kindly come up tomorrow, my lord.
Second appeal.
Yes, it's a section 5 application in connection with the second appeal. And the next date for execution for police help is on the 26th.
Second is section 5 application served upon the.
Yes, we have served. But this has happened because it was listed before a division bench, unfortunately, which consumed the time. It should have been before your lordship, before a single bench.
No, order 41, rule 11, that stage is over.
No, that stage is still there. But since it was supposed to be before a single bench, it was listed before a division bench. The division bench had to then.
The order 41, rule 11 is to be taken up. Huh?
No, first the section 5 has to be taken up. The limitation has to be controlled.
Abar jabe. Only section
Yes.
5 application.
Yes.
My lord,
Tomorrow, madam. And wait.
Extension, my lord. Extension of interim order.
my lord, I have a prayer for an urgent move, unlisted move, because the urgency is that the lady has been dispossessed from her home. We have, my lord, we have prayer, we have
Listed up. Yes.
My lord, this is an extension of interim order, my lord.
Extension below nearly.
Item 1, my lord, it appeared under the heading extension of interim order. But my lord, there was no interim order in this. My lord,
Lordship, in item number 1, Lordship, I have mentioned it the other day, Lordship. I have prayed for extending the time for filing of the affidavit in opposition. Lordship.
okay.
I'm praying for extending the time period, Lordship. Kindly grants me 2 weeks of time, Lordship. The petition, the OP number 1, whom I am representing, Lordship, he is sick, Lordship. He is a senior citizen and he is bedridden. That's why.
So and so learned advocate for the petitioner.
But I am for the petitioner, he is for the opposite parties.
I am for the OP number 1, Lordship.
Opposite party number 1 seeks extension of time period for filing the affidavit in opposition, which was directed to be filed by 14 June 2024. Let such affidavit in opposition be filed. Next, এটা কবে আসছে? Filed by 8th July 2024. A reply thereto, if any, be শেষ হচ্ছে 19th না 1st জুলাই হলে 12 জুলাই শেষ হচ্ছে তাহলে একটা কাজ করুন filed by 5th you are for the petitioner
Petition.
5th of July করুন filed by the 5th of July and reply thereto if any be filed by 9th July
9th,
after 4 days
4 days.
let the matter be placed before let the matter appear available circuit bench
Grateful, Lordship.
Well, item number 2, my lord, I beg to appear for the petitioner, my lord, this is for extension of interim order. My lord, we prayed for quashing of the FIR, my lord, at the first instance, my lord, Justice
I'm for
Ghosh.
the opposite party number 2. The lordship kindly comes to the order dated 1st of May 2024, passed by his lordship Honorable Mr. Justice Krishna Rao. When there is a direction that another matter, that is CRR 157 of 2024, should be heard analogously. Well, let's kindly takes up the matter tomorrow
No.
and let
No,
that
let-
file be tagged with that.
this is an application for extension which order
Well, it's 1st of May 2024, kindly cease. As I'm being led by Mr. Debojyoti Basu, he will be appearing personally before your lordship. If your lordship kindly takes up the matter tomorrow under the same heading, we have an objection to that for
No, we can
extension. Well,
next-
let
next-
those two matters be heard
No.
analogously for extension of interim order. I am not
since
on the hearing of the
one
matter,
similarly
my lords.
present both the application be heard simultaneously. Then to appeal, this is an application for extension of interim order. 1st May.
You am for the state lordship.
Mr. Swentul, an advocate for the petitioner, seeks for extension of the interim order. Mr. Swentul, an advocate for opposite party number 2. Submits that this matter along with CRR 157 of 2024 was directed to be heard simultaneously.
The other matter has been mentioned today, probably it will appear tomorrow. The other
Which one?
matter. The other matter which is
Mention for extension of interim order.
today I have
In
mentioned it.
that matter,
The other one. Two.
Under the same heading.
Did it?
that is filed by you. 157.
Both the matters are filed by us.
Petitioner, I am for the opposite party number.
Well, one FIR, 2 accused persons, both of
In
them
that
are
also
per-
interim order. is
Yes,
not?
yes, interim order is.
The same.
Let the matter, let the matter appear before the next available circuit bench. Let the interim order be extended for a period of 4 weeks or until further order, whichever is earlier.
Grateful.
Party shall be let the matter appear before the next available circuit bench. Tomorrow, when the 157 is taken up, you just indicate.
Yes, I will.
Plan 2 of 22 disposed of.
Divakar, this is-
I am for the petitioner, your lordship. My lord, this is the application for quashing of FIR against me. I am the accused number 7. And the case was registered under section 447, 341, 323.
Where is
354.
this?
Yes, your lordship.
Who is for the opposite party number 2?
I not made him a party, your lordship.
Huh?
I'm not made him a party, your lordship.
This,
Soft copy to us.
oh, motion state.
Yes, your lordship.
Yes.
May I, your lordship? Lordship, the brief fact of the case is that on 11th of October,
at about 9 AM, the accused petitioner family member come to the house of the de facto complainant. And it was specifically mentioned in the FIR that accused number 1, 2, and 3 are molest the de facto complainant. On the basis of that, she made a complaint before the Shitulguchi police station. It is pertinent to mention here that, Your Lordship, at 9 AM, the alleged incidents was occur. And being I as a accused person, number 7, I was on my duty. My duty was start from 8:30 to 12 PM, Your Lordship, being as a Anganwadi helper. And it was specifically
9 AM.
9 PM, sorry, Your Lordship. 9 PM. No, sorry. 9 AM to 12 PM. And the alleged incident was occur at 9 AM.
Here is duty.
Yes, Your Lordship. The duty attendance, Your Lordship, annexure P2, page 16. 16 and 17, Your Lordship.
And page number?
Page number 16 and 17, Your Lordship.
What is his name?
Swapna Dakua Burman.
Swapna? Swapna Vermont.
Dakua, Your Lordship. Swapna Burman Dakua. In FIR, Milord, there was no direct allegation against me. The direct allegation was against the accused person number 1, 2, and 3, Your Lordship.
You are accused number 7.
Yes, Your Lordship, 7.
Okay. Yes.
My lord, at this stage, on the basis of the attendance register, my lord, whether he was present at that time and the allegations are, so it's very difficult to come to a conclusion, my lord. Because time 9 is given, so it may be 8:30 or
You produce the
9.
case diary.
My lord.
Let the proceedings against this particular person. What have you prayed for?
Quashing of FIR against me, Your Lordship.
And stay.
Huh?
Stay precious.
Stay torture. And stay the proceeding, Your Lordship.
Ashwin. This is an application under section 482 of the Code of Criminal Procedure, hereinafter referred to as the code, for quashing of proceedings. Arising out of Shitolkuchi Police Station, case number 311 of 2023, dated 11th October 2023, under sections 447, 341, 323, 354, 506, 34 of the Indian Penal Code. Hereinafter referred to as, in short, IPC, within bracket, corresponding to GR case number 1321 of 2023. Mr. Swenso, learned advocate for the petitioner, submits that the petitioner is a Anganwadi worker and her working hours commences from 9 AM. The time of occurrence as per the FIR is, what is the time? Time of occurrence?
9 AM, your lordship.
at 9 AM. The petitioner on the alleged date of occurrence attended her office. Stop. At the time of occurrence, she was not present. Full stop. There are no direct allegations against the petitioner in the written complaint. He seeks for stay of proceedings against the petitioner. Mr. Niloy Chakraborty, learned advocate for the state, submits that the case diary is required to be gone into for adjudication of the allegations, for consideration of the allegations against the petitioner. From the attendance sheet. What is the date of occurrence?
11th of October, 2023, your lordship.
11th October. From the attendance register, it is found that the petitioner attended her office on 11th October 2023. The considering the nature of allegations made in the FIR, I am inclined to, this court is inclined to grant a order of stay. Revisional application is admitted. The proceedings against the there shall be stay of proceedings. You consult this for a period of 4 weeks or until further order, whichever is the party shall be at liberty to play for with the petition is directed to serve serve and implead both you implead the complainant. Petition is directed to implead the complainant as party opposite party, sorry, it is the party opposite party in the present revisional application. Petition is directed to serve copy of the application along with annexures upon the opposite parties and file affidavit through registered speed post with acknowledgement due and file affidavit service on the returnable date. Let the matter be placed before the next available circuit bench.
Much obliged, your lordship.
Implead the complainant as a opposite.
Okay, your lordship. Much obliged, your lordship.
My lord. My lord, it is with that matter, my lord remembers the Foreigners Act, my lord. My lord, kindly pass it over because my lord, the affidavit of service is being prepared by the clerk. The service has already been made effective with.
Motion is under your
My lords, my,
Pass over.
my.
Give a notice to the state.
We have served this state.
No, section 5 আছে। হ্যাঁ? Section 5 টা শুনতে হবে না, নোটিশ দিয়েছে স্টেট কে, কি স্টেটের আছে। নেক্সট। Not today.
Lord, item 6, I appear for the petitioner, my lord. May it please your lord. Lord, this is the case. My lord, instituted under section 195 capital A, 201 and 120B of the Indian Penal Code. My lord, the facts in brief is that, Lord, the petitioner before your lordship, Lord, was facing a prosecution under section 8 of the POXO Act, Lord, 8. Lord, this honorable court, Lord, granted anticipatory bail to the accused person. Lord, thereafter, he surrendered before the trial court. Lord, he was facing trial. Lord, after almost 13 witnesses were examined. Lord, thereafter, this present case, my lord, this was instituted by the investigating officer of that case, of the previous case, my lord, stating that he has, my lord, somehow influenced the victims of the case. My lord, there were 4 victims. The allegation was a molestation. My lord, he has somehow influenced the victims, and as such, my lord, this present case, was instituted under 195A, 201 and 120B of the Indian Penal Code. Now, my lord, from the genesis, it is clear that a second case from arising from the first case, my lord, has been filed. That is not my contention. My contention is, my lord, the law on section 195A of the IPC is very clear, my lord. Under what circumstances, my lord, a case under 195A can be filed. And my lord, 120B, lordship knows criminal conspiracy, my lord, cannot happen singularly, my lord. There has to be more than one accused person involved in a case, my lord, in order to attract this section 120B of the IPC. Now, my lord, I will lordship will find the FIR.
201, what is it?
Yes, lordship has seen, my lord, in page number 19. The written complaint is there, my lord. My lord, one police personnel files the written complaint, and on the basis of this, my lord, this has been started. My lord, the law says my lord, the law says under what circumstances, my lord, a prosecution under 195A is maintainable. My lord, the person who is threatened, not influenced, who is threatened, my lord, he or she can approach the concerned court where the trial is going on. My lord, and on the basis of a finding of the concerned trial court, my lord, a prosecution can be started under 195A of the IPC. Lord, I'll draw your lordship to 195A once, my lord.
Yeah. Yes.
My lord, 195A says, whoever threatens another with any injury to his person, reputation or property, or to the person or reputation of anyone in whom that person is interested, with intent to cause that person to give false evidence, shall be punished with imprisonment of either description for a term which may extend to 7 years, or with fine, or with both. And if innocent person is convicted and sentenced in consequence of such false evidence, with death or imprisonment for more than 7 years, the person who threatens shall be punished with the same punishment and sentence in same manner, and to the same extent such innocent person is punished and sentenced. So, my lord, from the literal and plain interpretation of the statute, Lord, it is very clear that the person who has been threatened, Lord, he has to go before the concerned court and he has to give the information that I have been threatened to give false evidence, and my lord, on the basis of that, my lord, the prosecution can be started. And my lord, this 195A of IPC, my lord, is being governed by 195 of the CR, section 195 of the CRPC, which explains the procedure, my lord, as to how such prosecution can be started. There can be no direct involvement or no direct case before the police. But a judicial entity has to come in play, and only on the basis of finding of a judicial entity, my lord, a case can be started under 195A of the IPC. Now, my lord, it is not, my lord, me saying this. My lord, the Honorable Supreme Court is saying this. Lord, one very recent judgment, 2023 judgment of the Honorable Supreme Court. Now, my lord, page number 5, paragraph 50. Para 15, my lord. May I read, my lord? It says, there is a different angle to this matter. It appears that the investigating agency has invoked section 195A of the IPC. Section 195A of the IPC reads thus, and then the section was extracted. Next, my lord, para 16. A plain reading of the aforesaid provision indicates that if any individual is threatened with any injury to his person, reputation, or property, and such threats are administered with intent to cause that person to give false evidence, the same would constitute an offense under 195A of the IPC. In our opinion, none of the ingredients to constitute the offense punishable under 195A of the IPC are disclosed. On plain reading of the FIR and further statement of the first informant, including the statement of the so-called eyewitness, the allegation in the FIR is that the accused person threatened and pressurized the first informant to withdraw the first FIR bearing number so and so, registered for the offense punishable under section 376D, 323, 120B, 354A, and 452 of the IPC. There is nothing to indicate that the accused person threatened the first informant with intent that the first informant gives false evidence before the court of law. The latter part of section 195A makes it very clear that false evidence means false evidence before the court of law. On such false evidence, if a person is convicted and sentenced, then the person found guilty of administering threats would be liable to be punished with the same punishment and sentence in the same manner and to the same extent as such innocent person is punished and sentenced. The word false in section 195A should be read in the context with what has been explained in section 191 of the IPC, which falls in chapter 11 of false evidence and offences against public justice. Thus, even if we believe the allegations leveled in the FIR to be true, none of the ingredients to constitute the offence punishable under 195A are disclosed. To give threat to a person to withdraw a complaint or FIR or settle the dispute would not attract section 195A of the IPC. In the aforesaid context, we must look into section 195A of the CRPC. Section 195A of the CRPC reads thus, 195A, procedure for witness in case of threatening. A witness or any other person may file a complaint in relation to an offence under 195A of the Indian Penal Code. And the plain reading of the aforesaid provision indicates that if a witness or any other person receives threat and such threat are administered with an intent to cause the person to give false evidence before the court, then such witness or person can file a complaint in relation to the offense under 195A of the IPC. It goes without saying that such complaint has to be lodged before the court recording the evidence. Section 195A of the CRPC provides a remedy of filing a complaint. Complaint means as defined under section 2D of the CRPC, which reads thus: section 2D, complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offense but does not include a police report.
In these proceedings, you have taken bill. Your Honor.
Yes, yes, yes. I have taken bail.
The second one,
Second one, I have taken bail from the court below. And my lord, next page, my lord, para 25. Bottom part of the page, my lord. It says, however, as observed earlier, the entire case put up by the first informant on the face of it appears to be concocted and fabricated. At this stage, we may refer to the parameters laid down by this court for quashing of an FIR in the case of Bhajanlal Supra. The parameters are discussed, my lord, thereafter. And my lord, parameter number 6, lordship will find where there is an my lord, found next page, page 8, where there is an express legal bar engrafted in any provisions of the code or the concerned act under which a criminal proceeding is instituted to the institution and continuance of the proceedings, and or where there is a specific provision in the code or the concerned act providing efficacious redress for the grievance of the aggrieved party. So, my lord, I fall under category 6 of Bhajanlal, my lord, parameter 6. My lord, next, 26. Last one, my lord, I'll be referring. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under section 482 of the CRPC or extraordinary jurisdiction under article 226 of the Constitution to get the FIR or the criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance, then in such circumstances the court owes a duty to look into the FIR with care and a little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, then he would ensure that the FIR complaint is very well drafted with all the necessary pleadings. The complainant would ensure that the averments made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averments made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and, if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under section 482 of the CRPC or article 226 of the Constitution, need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to initiation registration of the case, as well as the materials collected in the course of investigation. Take, for instance, the case on hand. Multiple FIRs have been registered over a period of time. It is in the background of such circumstances the registration of multiple FIRs assumes importance, thereby attracting the issue of wreaking vengeance out of private or personal grudge as alleged. So, my lord, from the observations of the Honorable Court with respect to the bar under section 195 of the Code, my lord has already seen that there is a specific procedure laid down under the code, my lord, which has to be invoked if a prosecution under 195 capital A of the IPC has to be launched. Now, my lord, in the present case, neither the FIR, the contents of the FIR, nor the procedure adopted in the present case is in consonance with the principles of law. And, my lord, as such, the prosecution itself is bad in law, my lord. So, my lord, though I am in bail, but, my lord, I have challenged the entire proceedings before your lordship. My lord, I am praying for a...
Who is the complainant? The
complainant is the
investigating
police
officer?
personnel. Yes, my lord.
Investigating officer?
Yes.
Ashun.
Lord, I'm praying for a limited period stay in the matter.
Hmm? This is an application under section 482 of the Code of Criminal Procedure. For quashing of proceedings being GR case number 257 of 2023 under sections 195A slash 201 slash 120B of the Indian Penal Code, in short IPC, arising out of Kalimpong Police Station case number 120 of 2023 dated 10th September 2023, pending before the Court of Learned Chief Judicial Magistrate, Kalimpong District, Kalimpong. Mr. Ojun Chaudhary, learned advocate for the petitioner, submits that the petitioner is facing trial in respect of an offence under section
8 of POXO Act.
8 of the POXO Act, where prosecution has already examined how many witnesses?
14 witnesses.
14 witnesses. During the course of trial in the aforesaid proceeding, the investigating officer has lodged a complaint against the petitioner with the contention, with the allegation of threatening and manipulating the witnesses. On the basis of such complaint, the present FIR being Kalimpong PS case number 120 of 2023 under section 195 capital A slash 201 slash 120B of the IPC has been registered against the petitioner. He submits that proceedings under section 195A of the IPC can be lodged only by a witness or any other person who receives threat. The complainant in the present case is neither the witness nor is a person who has been threatened by the petitioner. Therefore, the entire proceedings under the said provisions of the Indian IPC, is vexatious and baseless. To buttress his contention, he relies on the decision of Honorable Supreme Court passed in Salib alias Shalu alias Salim versus State of UP and others, reported in Jalpaiguri 2023. I mean, underline 11 is CR 58. he seeks for stay of the proceedings pending before the trial court. The present proceeding has been registered under section 195A, 201 and 120B of the IPC. With the allegation of, where is the paragraph of threat in the FIR?
Not threat, Lord, there is a manipulation.
With the allegation of manipulating the witnesses
Page number 20, three.
manipulating witnesses in a proceedings under the POCSO Act. (195A) of the Indian Penal Code is in respect of threatening any person to give false evidence. (195A) of the CRPC provides that any witness or any other person may file a complaint in relation to offence under 195A of in relation to an offence under section 195A of the IPC if he receives threats. The complaint in the present case has been lodged by Lady Sub-Inspector Kalimpong, no? This is Kalimpong PS, Kalimpong Women PS.
Lord Kalimpong PS.
LSI is of Kalimpong.
She is of a different police station. She lodged it before Kalimpong PS.
Acha. LSI Kalimpong. OC Tista CP. OC Tista CP. CP. She is neither a witness, she is not the witness.
He is one of the witnesses, Lord, in the previous case, being the investigating officer.
No, does the complaint say that she has been threatened?
No. She said,
She-
Lord, the other.
She is not the person. No, she is not the person to have received threat. Such being the position, I find substance in submission of Mr. Chaudhary relying on Salib alias Shalu alias Salim. The proceedings being ওখান থেকে নিয়ে নেবেন প্রথম থেকে pending before this state for a period of 4 weeks or until further order, whichever is earlier, with the matter. Petition is directed to serve notice along with annexures of this application upon the opposite party. Only state is the party?
Yes, my lord.
State of West Bengal. And file affidavit of service on the returnable date. Let the matter be placed before the appellate.
I'm grateful to your lordship. Lord, item 7, my lord, on Friday was adjourned on my prayer because I intend to move this application in presence of the opposite party, my lord. But my lord, the track report I my lord, took out yesterday, it shows, my lord, not yet this delivered. My lord, one more day if I get, my lord, I believe it will be delivered.
Okay, let it come up before the next available submission.
My lord, tomorrow, let it be in the list, my lord.
Tomorrow
But
will not be-
kindly, my lord.
Mr.
Because the
Ojjwal
trial
Chaudhary
is
done an
going on,
advocate
my
for
lord.
the petitioner submits that the service upon.
My lord. I'm sorry, my lord.
This is 182. Seven is Babita Mandal.
I'm sorry, my lord.
Yes, yes.
The vehicle of the petitioner was seized by the investigating officer in connection with a NDPS case. And the petitioner made a prayer for release of the vehicle. The order was passed in favor of the petitioner. But there was a condition to furnish bank guarantee or cash surety of 4 lakh rupees. The petitioner is an unemployed lady, lordship. She is unable to furnish that bond, lordship. I am praying for modification of the condition. This is the first time, this is the first time service has not been effected.
What service? Go before the trial court. Seek for modification of the order before the trial court which has passed the order. What is there in the revisional application?
Lordship, let me soft copy and come back.
No. Dispose of the revisional application directing you to take appropriate steps before the trial court which passed the order. Or we withdraw this application and go before the trial court and file an application. The court which passed
So
an
let
order,
me
you have
take
not filed an
instruction.
application for modification of the order, why you have filed the revisional application? Let the court consider. What you will do?
No, I will.
Learned advocate for the petitioner seeks to withdraw the, intends to withdraw the present revisional application. In view of such submissions, the revisional application being number 182 of 2024 stands dismissed as withdrawn. Or interim order. Not today, to Calcutta, you get a resolution, I think.
Item 9. Item 10. Item 11.
10 or 11?
11, my lord.
11.
My lord, I had before everything else, my lord, my gratitude to your lordship, my lord, for accommodating me this matter.
Okay.
My lord, an utterly malafide proceeding, my lord. I just give the background, then I will take your lordship to the relevant page. My lord, the petitioner before your lordship is a developer. He is the owner of few plots. Some of the plots were purchased by him personally. Some of the plots were purchased through a company. Now, there are local hooligans who started throttling the process of development by throwing spanner. Well, a civil suit filed by the petitioner where an interim order of status quo was passed. Some of the opposite parties therein, the defendants, filed counterclaim. They also obtained status quo in respect of the properties, which was owned by the petitioner, individual. Post that, what they have done, since the construction work was going on, so far the plots are concerned, which were owned by the petitioner through the company, one after another FIR against the workmen who are employed there, Then ultimately,
Who are filing these FIRs?
the local hooligans, few of who are the defendants in the civil suit. No,
what was the counterclaim by this person who have no interest in the suit?
Exactly, they did not have anything, baseless claim. Despite that, my lord, an interim order. But it is a civil claim, my lord, so I'm litigating it before the civil court. Now, my lord, we filed a writ petition before this honorable court under 226, requesting for registration of FIR. My lord, one responsible officer of the state made a statement before this honorable court. I will take your lordship to those papers, my lord, that pursuant to our letter of complaint, FIR had already been registered, which was not in fact done till date. So the FIR, my lord, the writ petition was disposed. Post that, my lord, the police suo motu invoked 144 against the petitioner, saying that there is a chance of breach of peace. Now, in that 144 order, my lord, numerous FIRs were mentioned, which were against, my lord, the workmen, and the FIR which we filed, my lord, against, my lord, where, my lord, which was recorded in the writ petition, writ court's order. But from that, my lord, 144 order will be evident, my lord, that the FIR was registered after disposal of the writ petition. But we filed 226 again before this honorable court. Justice Krishna Rao, my lord, when he was taking up the matter, passed a detailed order, thereby quashing 144, my lord. A detailed order, my lord, in the writ over 226. Now, my lord, post that, how the criminal jurisdiction was ignited, one lady cried up that, look, she was for a different, as she was from a different locality altogether, my lord. I am from Darjeeling and she's from Siliguri. She said that when I was going to field, the gentleman came and inappropriately touched me. Now, my lord, in the FIR, if your lordship sees, I will take your lordship, who does not know me, she mentions my name, my father's name, my address, and towards the bottom of the FIR, your lordship will see who was the scribe of the FIR, a law clerk of a court. But an utterly malafide proceeding must as a counterblast to all these cases. But one after another.
What happened after the writ court directed for registration of the FIR?
My lord, that was registered, that is going on, my lord. I just show, my lord, few pages to your lordship, my lord. I know it's a motion stage, fresh matter. I will not trouble your lordship much, my lord. If may I request your lordship to come to page 56, annexure P3. But this was the first order passed in 2022 by the civil court, my lord. Learned Admiral order dated 21st of November 2020.
Prior to that, you just take me to the plaint. What is the prayer made by the petition in the plaint?
But the plaint, plaint your lordship will have, my lord, at page, it starts at page, my lord, 47. If I may request your lordship to come to page 53, my lord. Perpetual injunction, my lord. Restraining, page 53, para 21, my lord. The plaintiffs crave for the leave of this honorable court under order to rule 2 of the CPC and prays for a decree for perpetual injunction restraining the defendants and their men and agents for entering into the suit land and from disturbing the peaceful possession of the plaintiff over the suit land in any manner whatsoever. Then, my lord, temporary injunction.
Yes.
Then, my lord, the order your lordship will have just after the affidavit at page 56. My lord, order dated 21st of November 2022, learned advocate for the plaintiffs moved the application for temporary injunction along with a prayer for ad interim injunction to the same effect against the defendants. Issue notice upon the defendant opposite parties, asking them to show cause, then so on and so forth, my lord. Then no caveat thereafter, having considered the submission of the learned lawyer for the plaintiff and also having considered the materials on record and balance of convenience and inconvenience as well as urgency, it seems to me that the plaintiffs have a good prima facie case to be gone into trial, and accordingly, I think it's a fit case restraining the defendants and their men and agents from causing interference in the peaceful acts for the possession of the plaintiff and forbidding them for encroaching any portion. That was the temporary order passed. Thereafter, the order of counterclaim, the counterclaim I have not annexed. The order at page 57, your lordship will have, is a status. Page 57, my lord.
The defendant number 12 is nobody as far as the
nobody as far as the suit property. So we are litigating that, my lord. We are fighting out in the civil court. My lord, thereafter kindly comes to, my lord, the FIR which we lodged at page 107, annexure P8.
Yes.
Or your lordship will see the date 26th of February 2024 addressed to the inspector in charge, Kotuwali Jalpaiguri. This is to inform and place on record and for immediate necessary action. The undersigned states as follows. Then the name of the company in first paragraph. Then number 2, the company is in the business. Paragraph 3, if I may place. It may further be mentioned that some time past the undermentioned complaints and their men and associates with the assistance of few antisocial elements have been visiting our aforesaid plots of land. Initially, we were aware of the motive. We are not aware of the motive, but gradually came to learn that they were bent upon extortion of the money. Then these were the allegations, so on and so forth. Then para 4, your lordship will have such unlawful activities gradually became a day-to-day affair, seriously affecting the lawful development of the work on the said plots of land. Then the description of the incidents were mentioned. Now, this document was not acted upon by the police, for which a 482 petition was filed. I will not take your, sorry, 226. 226 petition, I will not take your lordship. Sees the order at page 139 on 10th of April 2024. Page 139, annexure P10. My lord has got to, I'm mobilized. Affidavit of service filed in this court taken on record. Mr. Shuddho Sotto Banerjee, learned counsel appearing for the petitioner, submits that the petitioner is engaged with the development work at a particular piece of land where the petitioner is being faced with various obstructions by the local miscreants, including extortion of money. Drawing attention of the annexure of the writ petition, learned counsel submits that on February 26, 2024, they have submitted a complaint before the Kotuwali police station. They left hand side bottom of the said document shows that the receipt. Then, my lord, the next paragraph is very important. Mr. Sachansas Lanet State Council appearing for the respondent number 1 to 4 on instruction submits FIR has already been registered. So this statement was made, my lord, before this honorable court on 10th of April 2024. So, my lord, then, my lord, Justice Aniruddha Roy passed expeditious and effective investigation. I am not taking a lordship to those observations, my lord. See the next page, 141, my lord, annexure P11. Now, on 4th of May 2024, a suo motu 144 by the police, where, my lord, I may just request your lordship, my lord, to come to page 143. Your lordship will have, my lord, a list of cases wherein, my lord, the 5 is, my lord, 11th of April 2024. The order of this honorable court disposing the writ was on 10th of April. And the FIR was thereafter registered on 11th of April when a categorical statement was made before this honorable court that it had already been registered. It's a wrong statement. Now, my lord, from this we got to know, my lord.
Serial number is 8 is the FIR lodged by you.
I'm mobilized. And the 9 is the, my lord, the present FIR, which we have assembled before your lordship. We got to know from this.
Okay.
So your lordship from 144 order itself, your lordship will get, my lord, all these FIRs are related.
Okay, tell me 1 to 7
are against the workmen, my lord, which we are not assailing.
Okay.
Now, this 144 order was assailed by us. The order your lordship will have, my lord, at page 199, P13. It's a detailed order passed on 24th of May 2024. My lord, we will see 199. My lord, the relevant paragraphs, my lord, for the time being, if I may request your lordship to come to page 208, para 27. Inner page 10, para 27. Heard the learned counsel for the respective parties peruse the material on record and the judgment relied on by the petitioner. The respondent number 4, being the inspector in charge of Kotuwali Police Station, Jalpaiguri, had submitted a request to the respondent number 5 to pass an order under section 144 of the code. Then, my lord, the land mentioned, my lord, your lordship will get the description of the land. And in that application, respondent number 4 has also described about details of 9 FIR, which are as follows. My lord, the list I have already placed before your lordship. Thereafter, my lord, recording everything, my lord has observed in such at page, my lord, 212, para 31. As per the, sorry, my lord.
Yes.
I'm mobilized, my lord. As per the submission of the learned advocate, additional advocate general, the people of the locality submitted a representation to BLLRO, but in the report of BLLRO has not mentioned about the same. In the report, the BLLRO submitted that LR plots, my lord, the plots were mentioned under the possession of the local people and the total area is used as follows. The BLLRO also stated in the report that LR plots number such and such is used as private tea garden. The said BLLRO had submitted the report on 25th of April 2024 after the field inquiry by the revenue inspector. But in the report of BLLRO has not stated about any dispute over the said plot of land. The executive magistrate in the impugned order has also recorded that the block land and land reforms officer has not submitted much detail to the right title or interest of the plots in dispute. But in spite of the same, the executive magistrate has passed an order. So despite, my lord, after recording everything, my lord, at page 215, your lordship will have, my lord Justice Rao observed that this has infringed the fundamental right of the petitioner, and therefore, my lord, at page para 39, and quashed the, my lord, 144 order and allowed the writ.
Yes.
Now, my lord, after that, how the criminal jurisdiction was ignited, my lord, will kindly come to the certified copy thereafter, after page 219. Because, my lord, 218, if I may just draw your lordship's attention to, before I take your lordship to the FIR, it's the last document, 26 April 2024, my lord, I came back from Delhi, and 219, 20th, 2020, 22nd April 2024, I flew down to Delhi. Now the FIR was filed, my lord. The certified copy your lordship will have, if I may place, মহাশয় আমি লিপিকা দাস স্বামী বিপ্লব দাস ঠিকানা কোতোয়ালি জেলা জলপাইগুড়ি এই মর্মে জানাচ্ছি আজ সকাল 12/4/2024 বেলা I'm sorry my lord, I'm so sorry my lord, my apologies. My lord has got it. আমি লিপিকা দাস স্বামী বিপ্লব দাস ঠিকানা কোতোয়ালি জেলা এই মর্মে জানাচ্ছি যে গতকাল 22/4/2024 বেলা আনুমানিক 6টার সময় আমি গরু নিয়ে বাড়ি ফিরছিলাম, তখন বিনয় কুমার, দ্য পিটিশনার বিফোর ইওর লর্ডশিপ, পিতা শ্রী শ্যামসুন্দর শর্মা, শিলিগুড়ি বাজার পোস্ট থানা শিলিগুড়ি জেলা দার্জিলিং, আমাকে কুপ্রস্তাব দেয়। আমি রাজি না হয় আমাকে জোর করে জবরদস্তি করে এবং মানে দ্য নেক্সট লাইন আই এম নট রিডিং আউট ফর সোবরাইটি, দেয়ার আফটার আমাকে বলে তুই ছোট জাতে নোমশূদ্র মহিলা, তোদের ইচ্ছের কোনো মূল্য নেই, বরং আমার ইচ্ছে পূরণ করতে হবে। আমি কোনো ক্রমে তার হাত থেকে রক্ষা পাই, প্রকাশ থাকি। এই বিনয় কুমার প্রায় আমাদের এখানে আসে। এই বিষয়ে আমি স্থানীয় পঞ্চায়েত সদস্য পাড়া প্রতিবেশীদের জানাই, আমি উক্ত বিনয় কুমারের বিরুদ্ধে কঠিন শাস্তির প্রার্থনা করছি। দেন মাই লর্ড সিজ টুয়ার্ডস দ্য লেফট সাইড, অভিযোগকারিনী মাই লর্ড হু ওয়াজ দ্য স্ক্রাইব মতো পাঠ করিয়া দিলাম এবং সঠিক বলে সই করে। লেখক ও পাঠক শুভম মন্ডল, ল ক্লার্ক, সাচান সাচ কোর্ট, জলপাইগুড়ি। Now, my lord, according to the 144 order which was passed by the executive magistrate on the prayer of the police, this FIR finds place as part of the other FIRs relating to the land dispute, my lord. Now, my lord, as your lordship knows, my lord, I think, my lord, in item 6 only the learned counsel who was appearing, my lord, place, I have prepared a compilation for your lordship, my lord. Only the relevant, but I did not make more than one judgment as such, my lord. It's just for
placing Bhajanlal.
No, not as such, my lord. It's a development of Bhajanlal and jurisprudential development, if I may place. My lord, the item 3 he placed, my lord. Just coincidentally, I was in court.
Yes, yes.
Khalid versus Salu, your lordship has taken note of. Now, my lord, Salu was a case where Poksho was quashed. And just prior to that, my lord, the first one is Muhammad Ali, my lord. If I may just place that. My lord, at page 1, your lordship will have Muhammad Ali. It's 2023-10 scale, page 5 to 3. Well, the relevant para will be, my lord, para 12 at page 8.
Yes.
If I may place, my lord, at this stage, you would like to observe something important. Whenever an accused comes before a court invoking either the inherent power under 482 of the Code of Criminal Procedure or extraordinary jurisdiction under Article 226 of the Constitution to get the FIR or criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance, then in such circumstances, the court owes a duty to look into the FIR with care and a little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, then he would ensure that the FIR complaint is very well drafted with all necessary pleadings. The complainant would ensure that the averments made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it would not be just enough for the court to look into the averment made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emanating from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under section 482 of CRPC or article 226 of the Constitution, need not restrict itself only to the stage of a case, but it empowered to take into account the overall circumstances leading to the initiation, registration of the case, as well as the materials collected in course of investigation. Take for instance the case on hand. Multiple FIRs have been registered over a period of time. It is in this background of such circumstances the registration of multiple FIRs assumes importance, thereby attending the issue of wreaking vengeance out of personal, private or personal grudge as alleged. Well, this was reiterated. If your lordship kindly comes back to the index, my lord, I will not trouble your lordship with any further, my lord, with all these judgments. The next one, Iqbal, the same principle was applied, my lord, and a proceeding under 376, 354 was quashed. And the third one, my lord, POXO already, my lord, it was placed, and item 4, my lord, 376 was. So, my lord, this is utterly a mala fide proceeding, my lord. What I beseech, my lord, kindly issue notice and stay the proceeding till the next date of hearing. I am deeply obliged. Ashwin. This is an application for quashing of application under 482 of the Code of Criminal Procedure, hereunder referred to as the code for quashing of proceedings, being GR case number 1911 of 2024, corresponding to Kotwali Police Station case number 290 dated 23rd April 2024 under section 341/354 of the Indian Penal Code, in short IPC, pending before the Court of Learned Chief Judicial Magistrate at Jalpaiguri. Mr. Oyon Bhattacharjee, learned advocate for the petitioner, submits that the petitioner is a developer carrying on such development under the name and style of Messrs. Rajputana Realty Private Limited. The petitioner purchased land for carrying on the developmental work comprised within measuring more or less 2 acres. This is the land purchase 2 acres. 2 acres within RS plot number 123, Mauja, Barpatia, Police Station, Kotwali. A group of rank outsiders tried to obstruct the petitioner in carrying out such developmental work. Stop. The petitioner filed a civil suit, being title suit number 542 of 2022, wherein an order of status quo was passed by the learned civil judge. The defendants also prayed for a counterclaim in the suit.
the defendants, in order to stall the developmental work, has initiated multiple FIRs against the workmen, thereby jeopardizing the entire work developmental work. The petitioner filed a complaint before the local police station, however, since no steps were taken by the police authority, he filed a writ petition. Wherein direction was issued for registering FIR. After a lapse of considerable period, the complaint lodged by the petitioner was registered as FIR, being Kotwal PS case number 266 of 2024, dated 11th April 2020. A suo motu case was started at the instance of the police authority under section 144 of the CRPC, which is the date of initiation of the proceedings.
That was, my lord, on 4th of May 2024.
4th of May 2024. Challenging such proceedings, the petitioner filed a writ petition before this honorable court, being WPA 991 of 2024. Such proceeding under section 144 was quashed by this honorable court on 24th May 2020. From the from Pekidin, while disposing of the writ petition, the honorable court observed that though the executive magistrate in its order recorded that the block land and land reforms officer has not submitted details as to the right title or interest of the plots in dispute, but in spite of the same has proceeded to pass the order. On the date of occurrence, full stop here, on the date of occurrence, the petitioner was, he returned, when did he board? On 22nd April?
My lord.
From Calcutta to Delhi.
Obliged.
On the date of occurrence, he went to Delhi. Date of occurrence to near in 22nd April 2024. Stop. The petition of complaint has been drafted by a law clerk. Stop. There is no connection and or nexus of the petitioner with the alleged complaint. In light of his aforesaid submissions, he prays for stay of the proceedings under challenge. From the materials para placed before this court, it is found that the petitioner is a developer who has purchased certain piece of land for development of his work. There has been a title suit filed by the petitioner for on the plea of obstruction to the developmental work, in which the civil court has passed a status quo order. Acha, oh sorry. To buttress his contention, he relies on এই চারটে ডিসিশন দেবে হ্যাঁ এইখানে দেখুন কম্পাইলেশন আছে হ্যাঁ it is where is that report in 144 where it records 9 FIRs?
My lord, it's at page, my lord. Two, my lord, one, your lordship will have that also at page, my lord, 208. That will be more legible, my lord, as extracted by Justice Rao in the order, 208.
It is found that about 9 numbers of FIRs is registered before the Kotwali PS between the parties. At page 218, sorry, 219, it is found that the petitioner has boarded flight to Delhi on the date of occurrence, that is 22nd of April 2024. Considering the aspect and the submissions advanced on behalf of the petitioner, I find that an arguable case has been made out. Obliged. Accordingly, the revisional application is admitted. There shall be stay of operation of the proceedings being first for a period of 4 weeks or until further order, whichever is earlier. Party shall be at liberty to pray for extension. Petitioner is directed to serve copy of serve notice along with annexures to who are the to the opposite
But the
parties.
state and the opposite party number
to
two.
the opposite parties through registered speed post acknowledged due and file affidavit service on the returnable date. Let the matter be placed before the next available circuit bench.
Most of it. And may I take your losses leave?
Okay, thank you.
I'm okay.
Rashid, in this matter, Mr. Double AG Jajit Chaudhary is appearing for the state. He has not come to the Rashid. Kindly take it out tomorrow.
Then I'm fixing it on before the next available survey. Tomorrow it will not be possible. Mr. Learned advocate for the petitioner seeks accommodation on the ground of non-availability of Mr. Joydeep Chaudhary Lanet is AGP.
Double AG.
AAGP. Let the matter, in view of such submission, let the matter be placed before the next available circuit.
Madam, 14 and 16 I'm paying for next year.
Do you know the closing? 14 and 16. 14.
No. Petition. Jajit Chaudhary.
No, 14 to the Julian, learned advocate for the petitioner. 6 for placing the matter before the next available circuit bench. Huh? 15টা দেখে তবে 16টা পড়ি।
Lordship, I'm seeking for the next circuit, Lordship.
I'm for the OP.
Same order. 16টা Mr. Banerjee বলবেন। Next circuit. Same order.
17, I am appearing for the state, your lordship. I am ready with the case diary.
17, 18, no?
Here for?
I am for the opposite party.
Quashing of, they have claimed, quashing of proceeding law, 498 proceeding law.
And my lord,
You have filed the supplementary?
yes, yes.
Filed.
File, my lord, I have served with the copy.
They have filed, I have received the copy.
Not today, Cohen.
Not today.
Mm. 17 and 18 both, no? अच्छा।
20, 21, 22.
My lord, I am appearing for the private opposite party.
Neither. Not today.
My lords.
Lordship,
My lords, I am appearing for the petitioner, my lords, in item 23. My lords had directed us to, my lords, take instructions from the petitioner. He is, my lords, a 62-year-old Swiss citizen. My lords, I had a detailed discussion, my lords, and in fact, the case remains that, my lords, the petitioner had entered India on a valid e-visa. My lords, I will show that he was on a valid e-visa. My lords, in fact, the agency had in fact duped him and misled him into believing that he was allowed and authorized to enter India on a e-visa. My lords,
those are the facts to be decided in the trial. Has
my
it
lords, with great
begun?
respect. I'm so sorry, my lords.
Trial has begun.
My lords, the trial is yet to commence, my lords. The trial will commence in August. In my lords, respectful submission, if my lords may, my lords, allow me 1 minute. There is, my lords, no guilty mind. He was not apprehended by FRRO or anybody, my lords. He voluntarily goes to FRRO. If I may just show 2 pages to my lords. His, my lords, innocence is unequivocally forthcoming, my lords. My lords may please see, my lords, the FIR. And if my lords may please see page 15. This is, my lords, the intimation to the authority. Here, my lords, his e-visa and Swiss passport was also recovered. If I may just, my lords, draw my lords' attention to para 3. ISI Aditya Lamba, my lords, on page 15, if my lords may have it.
Who is for the state? Who appeared for the state?
Mr. Arjun Chaudhary, I'm led by Mr. Arjun Chaudhary. He is on behalf of the state. He's on court number 1, Lordship.
Get a passport. Ask him to come.
Lordship, may I be permitted to submit one thing, Lordship? Item number 19, Mr. Ranodip Sengupta will be appearing physically, Lordship. He is in court number 1, Lordship.
Passed over.
Passed over. I'm so grateful. I'm so heartily appreciative.
Lordship. Lordship.
Milords, I beg to appear for the.
Lordship, may I be permitted, Lordship, item number 19, can it be passed over?
Not today.
Lordship, can it be passed over? Lordship, kindly, Lordship. He is appearing, he will be appearing physically, Lordship. He is on hearing in the court number 1, Lordship.
Tomorrow is. Chalo.
Maybe tomorrow he is leaving, Lordship. That
I cannot help. এটা কি আছে?
Milords, I beg to appear for the opposite party in 24. Your lordship will recall, your lordships had directed the other side to serve as a copy. We've not received it yet, my lords.
What is?
My lords, they are my colleagues, my lords. My lords, and if I may, my lords, take a minute of yours.
No, no. Where is the petitioner? Who is for the petitioner?
My lords may see earlier orders also. This is what is happening in this matter. My lords, the trial court matter is fixed on 21st.
Tomorrow.
My lords, may I request, my lords, on 20th, my lords, I am in some personal difficulty.
Date
I'm grateful, my lords. I'm grateful.
20th.
25, 26, 27, 28.
27, I'm for the petitioner in this.
Opposite party?
Your lordship, actually the service has already been completed, your lordship. So. And this present case is with regard to the release of a vehicle, which was apprehended in a forest case under the Indian Forest Act, your lordship.
CO.
Actually, this present application was previously registered as WPA. Then upon the liberty granted by Honorable Justice Anirudh Roy and Justice Subra Ghose, this present matter was renumbered as CO. It's an application under Article 227 of the Constitution of India.
It is CRR number bolo. Criminal court order, civil court
Your lordship, that matter was renumbered as CO upon the order of Honorable Justice Subra Ghose.
Which order?
It was
order dated?
Order dated, your lordship. Just a minute, your lordship.
Civil revision, huh? Hello?
Order dated 1st of April 2024.
Order passed by district judge. What is the order impugned?
Actually, your lordship, I'm not going on the merits of the present case. The only order, I've annexed the order in page number 19 of the present application, your lordship. It was in the present petitioner had preferred an appeal before the learned district judge Darjeeling, praying for the release of the vehicle that was confiscated in this said forest case, your lordship. And your lordship, if you go through the order, if I can kindly bring your attention to the said impugned order, your lordship, in annexing page number 19, your lordship. Your lordship, if you could go to through the last two paragraphs of the said order, your lordship. Section 59, may I be permitted to go through the impugned order, your lordship. Your lordship, in section 59D deals with inter alia appeal against order of confiscation. It is not the appellant's case that the subject vehicle has been confiscated by the appropriate authority. There are no provisions of appeal against seizure of the vehicle by the Forest Department. The appeal is premature, one, and cannot be admitted. Your lordship, this present the confiscation order is annexed in page number 14 to page 17, your lordship. And your lordship, this confiscation was already actioned in by this order dated 29th June 2023, your lordship. And the district judge has observed that the confiscation process has not yet been proceeded and the matter is very premature. Your lordship, section 59D, the West Bengal amendments of the Indian Forest Act clearly states that the district judge has the authority to hear as an appellate authority to hear the matter for release of any articles seized in under the Act, Indian Forest Act. So, your lordship, I'm not going on the merits of this case. I'm just seeking for a direction so that this present misappeal cases that was dismissed, stating that the matter is not maintainable.
There is specific provision for appeal, my lord. But whether the appeal was in form or not, that he has not annexed. The copy of the appeal has not been annexed.
Where is the?
He has only annexed the confiscation order, man. Neither the order of the district magistrate, nowhere.
Page number 19.
No, it has not been annexed. Not in our copy. I'm getting it.
Your Lordship, I'm not going on the merits at all, Your Lordship. I'm just
And
seeking for a direction.
59A3 of Indian Forest Act.
59.
This is appealable order.
My lord, it's a revisable also, it's an appealable also. Well, I'll show.
But then why miscellaneous appeal?
But appeal is also there.
Appeal is there, whether it is a criminal appeal or civil appeal.
Well, before the authority, my lord.
Before the authority.
Authority. And against that order, a writ lies, my lord, not civil revision. And I'll show.
Where were you when the order was passed by this court for conversion of a criminal revision into?
No, man, what I'm saying, my lord, the order that he is challenging should be, he should prefer an.
There is an order of rejection passed by the authorized body.
My lord.
Which was challenged before the district judge.
Yes, ma'am.
A miscellaneous appeal was filed. Now, the authority concerned is dealing in a confiscation proceedings. Is it a civil proceedings or a criminal proceedings?
But
the confiscation has been made in connection with the offense.
Offense, my lord.
Then it is a criminal proceeding.
Offense that the vehicle was involved in carrying forest produce, my lord. That is the offense, my lord. It falls
in a
on
criminal proceeding. Why a miscellaneous appeal has been filed?
That he.
Your Lordship, most of the matters are for such a release of vehicles are filed as misappeal at Darjeeling District, Your Lordship.
Misappeal.
Misappeal.
No criminal appeal.
Not criminal. Misappeal, Your Lordship.
What show me the provisions?
Your Lordship, I don't have that at my disposal at the moment. It is at the presence of the petitioner. I just have this order and the instruction to seek for a direction, Your Lordship. As per the provisions laid in section 59D, the West Bengal amendments.
59D says for my lord, any person aggrieved by an order under section 59A or 59C. 59C is the revision, my lord, may within 30 days from the date of communication to him of such order prefer an appeal to the district judge having jurisdiction over the area in which the property and the tools, ropes, chains, boats, vehicles, or cattle have been seized and the district judge shall, after giving the appellant and the officer who passed the order an opportunity of being heard, pass an order confirming, modifying, or annulling the order appealed against. The order of the district judge under subsection 1 shall be final and shall not be called in question by any court. Hence, there is no provision for further appeal or revision. He has to prefer application under Article 226, Malad. Usually, these kind of applications are done in writ court, Malad.
That is the reason why, Your Lordship.
But
I'm seeking for just in direction
so
that my matter in merits may be heard before the learned district judge.
And Malad, he has not annexed, Malad. He has only
But
annexed
then he filed a writ petition before this court, which has been converted to a civil revision.
Oh. It was subsequently converted to a CRR, Your Lordship, upon my prayer, upon the prayer of the petitioner.
Upon his prayer.
It was converted to CRR. And subsequently, what learned Honorable Supreme Court observed is that the matter must be recorded as CO, as CRR cannot be registered under Article 227, Your Lordship.
And I have only page till 18, my lord. There is no other page, my lord.
Item number 19. Page number 19. Your Lordship, as per the order dated 24th of April 2024, Honorable Supreme Court.
Can't give that act.
Mana. Itu দেখাবেন। আমি দিয়েছি, বলতে দিয়েছি।
এটা অন্তত
ডিস্ট্রিক্ট জাজের অন্তত অ্যানেক্স করেছিল এখানে তো প্রতি যে কারণে বলতেছে ভেহিকল ইয়েটা কনফিসকেট হয়েছিল সেটা সেটা কিছু নেই ঠিক আছে? কিন্তু এখানে হ্যাঁ রিভলভার মেটেরিয়াল এবং উইথ একটা কনফিসকেট দুটোই হবে
ভেহিকল
হ্যাঁ
ফরেস্ট
কথা বলছি কিন্তু যে ভেহিকল রিলিজ করার জন্য কোনো অ্যাপিল হতে পারে এখানে ফরেস্ট প্রডিউস রিলিজ করে কোনো
এটা প্রসিডিংটা হচ্ছে কনফিউশন অফ ফরেস্ট অফিসার এইসব করবে ফরেস্ট প্রডিউসার তো হবে কনফিউশন সবই হবে
কিন্তু ভেহিকলটা
এটা এখানে হবে ইস্যু নোটিশ করবে হিয়ারিং হবে তার রিভিশন করতে হবে তারপরে যে না হয় এরকম
কিন্তু এখানে ভেহিকলটা
হ্যাঁ অর্ডার অফ
অর্ডার ঠিক আছে আমি ডিস্ট্রিক্ট অর্ডার করছি ভেহিকল ইউজ করুন
Appeal is 559D.
59D.
challenging the order passed under 59
or C.
or
What is 59G? Contrary to contained in this act of the Code of Civil Procedure.
Only the appeal and the decision or the content of authority.
59G.
Not. Country, the officer authorized under section 59A or the forest office specially empowered under section 59C or the district judge to whom appeal may be preferred under 59D shall have and any other officer or forest officer or court or authority shall not abuse. The judicial is specified.
B, G. For which? No. You are following which book?
Indian First in 19.
Page 77. Bottom.
Yes. Yes.
Bar of jurisdiction in certain cases.
Yes.
Read that.
Notwithstanding anything to the contrary contained in this act or Code of Criminal Procedure Act 1973 or in any other law for the time being in force. Yes.
So anything contrary to the Code of Criminal Procedure means there is applicability of Code of Criminal Procedure. How come you have filed a miscellaneous appeal before the district judge?
This was preferred under section 59B of the said Indian Forest Act.
That has to
The Code of Criminal Procedure, there is a chapter of appeal. It speaks of appeal. Now, is it speaking of civil appeal?
No.
So I'm asking you, how come you have filed a miscellaneous appeal before the district judge? This act says that you file an appeal. Will it be a civil appeal or a criminal appeal? Now, since miscellaneous appeal was filed, so it has been turned into an application under Article 227 of the Constitution of India and CO has been registered.
And Your Lordship, actually there are certain case laws which where this matter was preferred under section 482 of the CRPC, but was rejected by this learned court. That is by this honorable court. That is the reason why this present. Actually, I had preferred a writ petition with respect to this present of it. Then, upon the liberty, I again prayed before the Honorable Justice Anirudh Roy to renumber it as CRR, Your Lordship. Subsequently, when the matter was taken up for hearing, it was the observation of learned Honorable Subra Ghosh that the matter must be registered as CO under Article 227.
Okay.
It is upon order dated 24th of May, 24th of April 2024.
Okay. What is the
Your Lordship, I'm not pressing the merits at all, Your Lordship.
what is
What my prayer is, Your Lordship, let my matter be heard in merits as per the provisions laid down in the State Indian Forest Act. I had preferred an appeal under section 459D, and the state impugn order is annexed with this petition. The learned district judge was pleased to dismiss the matter being non-maintainable.
not maintainable?
Not maintainable. The impugn order is annexed in page number 19.
How it is not maintainable?
As per the observation of the learned district judge, it was stated that confiscation process is not yet been started, and the matter is very premature. Whereas the confiscation order was already passed when the state appeal was preferred.
From the very beginning, the approach has been mistakenly made. Is the file of the case lying before ACGM Siliguri?
Actually, Your Lordship, one application was preferred before the ACGM as well for the release of the state record. But the ACGM.
But Mr. Guru, try to understand. If an accused is produced before the ACGM Siliguri, you file an application for bail. If the accused is produced before CJM Jalpaiguri, will you file an application in ACGM Siliguri?
No.
Has the file of confiscation was with the ACGM Siliguri?
During the time when the petitioner preferred an application before the ACGM, it was not there, Your Lordship. But now the matter
How
has.
could you file an application before the ACGM Siliguri, who is not cessing of the matter of confiscation.
That was rejected for not being maintainable at all. That I'm not pressing, I'm not focusing on that impugn order, Your Lordship.
So misappeal arises out of the order passed by the ACGM Siliguri. Misappeal before the district judge. So how the district judge has rightly pointed out.
No, the district judge has pointed out that confiscation process has not been started, has not yet started.
If it has not been started, then where is the question of appeal?
No, Your Lordship, but as per the confiscation order dated 29th of June 2023, the confiscation process had already been started, Your Lordship.
Where is that order?
The order is annexed in page number 14, Your Lordship. Even prior to preferring the state appeal, the order was already passed by the authorized officer.
Now appeal has been filed against which order? Misappeal?
Now this appeal was preferred because the district judge.
Appeal was filed against which order?
Against the order of ACGM.
Then confiscation proceeding has been initiated by the DFO. You file application before ACGM Siliguri for release of the vehicle.
That was challenged before not the constitution.
Entire course of action is wrong.
Actually, the ACGM should not be the appropriate authority to approach for this present matter. I do bow down to the observation of this honorable court that the petitioner should have preferred a direct application under section 59D before the learned district judge.
Challenging the confiscation.
Challenging the confiscation process.
That was not done.
Okay. I dispose of this.
So a liberty may be granted. A liberty may be granted to approach the learned district judge against
filing appeals against the order of DFO.
Against the order of DFO.
Huh?
Against the order.
He be given a liberty to file an appeal against the proceedings initiated by the DFO. This civil revisional application is filed under Article 227 of the Constitution of India. Challenging order dated 6th October 2023 of Learned District Judge Darjeeling in miscellaneous appeal number 10 of 2023 under section 59D of the 59 capital D of the Indian Forest Act 1927. Mr. Procedural, learned advocate for the petitioner, submits that the miscellaneous appeal challenging the order of learned ACGM Siliguri for release of vehicle was dismissed by the learned district judge Darjeeling being not maintainable on the ground that the appeal is premature. No case made out of confiscation. You would know? Since no case of confiscation was made out by the appellant. By the petitioner. 14 is the order of confiscation.
Page number 14 is order of confiscation.
Mr. Paul,
Yes.
This- where is the paragraph? The vehicle has been confiscated.
17,
Page
last
number
paragraph.
17.
Page 17, last paragraph. I authorize the
Ah,
person to
Acha.
order confiscation.
However, the Divisional Forest Officer Karsian Division Karsian, no, his rank is Divisional Officer Karsian Division. By its order dated 29th June 2023, has already passed order. It's a tractor
It's a tractor.
for confiscation of the seized tractor.
Along with river
Yes,
bed
it's-
materials.
Yes,
Along with the river.
along with riverbed materials. He submits that the application made to learned ACGM Siliguri for release of the vehicle was not proper. So is there any provisions that application can be filed before the DFO for release of the vehicle?
He has to challenge the entire confiscation order.
Okay. He seeks liberty to challenge the confiscation order passed by the Divisional Forest Officer, Karsian Division. Mr. Novankur,
I'm led by Mr. Gilot.
Mr. Hirok Bormon, learned advocate for the state, no? Submits that the appeal filed before the learned district judge Darjeeling is misconceived. Sorry, challenging the order of learned ACGM Siliguri is misconceived. Be that as it may, he also submits that liberty is granted to the petitioner to file appeal before the learned district judge, challenging the order of confiscation passed by the Darjeeling, passed by Divisional Forest Officer Karsian Division. Para. The facts as diverge from the materials is that the petitioner filed an application before learned ACGM Siliguri for release of the vehicle, whereas the confiscation of the vehicle has been made by Divisional Forest Officer Karsian Division. The ACGM Siliguri turned down the prayer of the petitioner for release of vehicle with the observation that it lacks jurisdiction. The said order of the learned ACGM Siliguri was challenged in appeal being miscellaneous appeal 10 of 2023 before learned district judge Darjeeling. Stop. No case of confiscation was made out in the appeal by the petitioner. petitioner in appeal. The district judge dismissed the appeal being not maintainable, observing that the appeal is premature. It is not in dispute that an order of confiscation has been passed by Divisional Forest Officer, Karsiang Division, in respect of riverbed materials and tractor seized as per section 59 capital A within bracket 3 of the Indian Forest Act 1927. In view of the above, the present civil revision is disposed of, granting liberty to the petitioner to file appeal before the learned district judge, challenging the against the order of confiscation. The disposal বললাম না? All connected applications.
Lordship, humble indulgence. Let the matter be discussed in the, decided upon the merits of the case, may be reflected in the order sheet.
Giving you liberty to file afresh.
Very grateful, Lordship. Grateful.
Again, then it has to be said that yes, you have not made out a case of confiscation. Go and file an appeal before the district judge.
May I get back?
Oh, sorry. Let the book be here after you take it back from the court office. এখন রাখুন।
28 additional advocacy is appearing in this matter on only ground and praying not for them.
28.
Only not for them.
What is this case?
No,
Oh, you were not in-
this is the case where the execution proceeding has been proceeded on the basis of an order passed by the district review committee, my lord, not which was considered as an award, my lord. It was admitted, my lord. But kindly takes it up tomorrow, my lord, he shall address you.
Not today, good.
My lord, grateful, lordship.
I am for the petition.
Item number?
29. 30, I am for the petition. Revision list. Lordship, in this case, I am challenging the order passed by the executing court, dismissing my execution application on the point of.
Yes.
29 minute I appear for the petition.
29.
29 minute.
29. Wait, not today. The other side is
My
not.
lord. But it's there is no caveat. There is no caveat. It's a revisional application.
The other side is not here. No?
My lord, there is no caveat in this matter.
29. Then 29 again. Motion stage of it. 29.
No, my lord, but I am the respondent wife in a suit for divorce.
But I am the respondent wife in a suit for divorce. Now, my lord, my application under Order 7, Rule 11 has been rejected by the learned my lord court below. Now, my lord, lordship would kindly, my lord, take 2 dates. First is, my lord, it is admitted in the plaint that the marriage was solemnized socially on 4th of February 2020. And my lord, it was registered on 26th of September 2020. But it is admitted in the plaint, lordship would get that, my lord, at my lord, paragraph number, my lord, page 21, paragraph numbers 1 and 2.
Page 21.
Page 21, paragraph numbers 1 and 2. My lord, the social marriage is held on 4th of February 2020. And next para, my lord, the registered marriage takes place on 26th of September 2020. Lordship would get that date. Well, it is admitted. But at first paragraph, that the crux of the case is that your respondent is the wedded wife of the petitioner and the marriage between them was registered on 4th of February 2020 at Hill Queen Residency, Shiv Mandir Medical More, Matigara, Kodamtala, Darjeeling. Lordship has got that date. And my lord, in his claim, my lord, he admits, my lord, in paragraph number, and lordship would get that from the judgment as well, that the marriage was registered thereafter on 26th of September 2020. If your lordship comes to the judgment impugned, my lord, which is the last page of your lordship's brief, my lord, second last paragraph from the bottom, prima facie from the documents being marriage registration certificate of the parties, it appears that Hindu marriage was solemnized on 4th of February 2020 and subsequently the marriage was, my lord, the certified copy, the order impugned. My lord, 2 paragraphs from the bottom. Prima facie from the documents being marriage registration certificate of the parties, it appears that Hindu marriage was solemnized on 4th of February 2020 and subsequently the marriage was registered on 26th of September 2020. So, my lord, 2 dates. First is social marriage held on 4th of February 2020 and registered on 26th of February 2020. Now, my lord, the husband files this suit for divorce on 25th of January 2021, which is within 1 year. Well, lordship would get that date at Annexure A at page 20, the seal of the court, that the suit is filed on 25th of January 2021. Now, my lord, if your lordship takes up section 29 of the Special Marriage Act.
What is Special Marriage Act?
Well, that's section 29. May I place section 29, subsection 1? No petition for divorce shall be presented to the district court unless at the date of presentation of the petition, 1 year has passed since the date of entering the certificate of marriage in the marriage certificate book. But there is a proviso that one can file a suit for divorce within a period of 1 year, but are subject to the condition that there is some exigency involved, and that exigency has to be brought to the notice of the court, and the court, my lord, can grant leave to file it within 1 year. Well, here nothing was done by the husband. But nothing was done by the husband, my lord. No petition praying for leave, my lord, before the learned court below was there. Now, my lord, the learned trial court, my lord, went on a completely different footing and dismissed my application under Order 7, Rule 11. My lord, this plaint in my humble submission, my lord, has no cause of action because the plaint is filed before the court within the period of 1 year. And Section 29, my lord, of the Special Marriage Act, there is a specific bar in entertaining the suit. But if your lordship sees petition for divorce will be presented to court one. Once the date of presentation of the petition, 1 year has passed. Since the date of entering the certificate of marriage, marriage certificate, provided that the district court may, upon an application being made to it, allow a petition to be presented before 1 year has passed on the ground that the case is one of exceptional hardship suffered by the petitioner or of exceptional depravity on the part of the respondent, but it appears to the district court at the hearing of the petition that the petitioner obtained leave to present the petition by misrepresentation or concealment of the nature of the case. That is not the case here.
Yes.
The district court may, if it pronounces a decree, do so subject to the decree shall have not effect until the expiry of 1 year from the date of
But
marriage.
then this
Or may
this
dismiss the
ground was
petition
not
without
taken in the
prejudice to
written
any-
statement. You have not taken this in the written
But
statement.
that was taken. Kindly come. Yes, my lord, I have taken this ground in my Order 7, Rule 11 PTI. My lord, Order 7, Rule 11 as well. Kindly come to page 36.
No, in the written statement,
Paragraph 4.
written statement, you have not stated this ground.
But in the but I have written statement, I have stated this ground in my Order 7, Rule 11 also I have taken this ground.
In the written
Kindly comes to
statement,
page 37.
Mr. Das, in written statement, which
But
paragraph?
written statement. But may I show it to you, lordships? But in this suit, my lord, till date I have, but kindly comes to my written statement. Your lordship knows, my lord, if Order 7, Rule 11 is filed, my lord, court should consider the Order 7, Rule 11 at the first instance. Now, my lord, if Order 7, Rule 11 is allowed, my lord, the entire suit goes. So, my lord, I need not even file my written statement, or even if I have filed my written statement, I need not take this point. In my Order 7, Rule 11 application, I have categorically taken this point.
No.
But page 37, paragraph 4.
No. Under Order 14, the bar of suit is a provision there where the court has to first decide whether the suit is at all entertainable.
Lordship.
So if a issue is not raised in the written statement, then what will be its
My
consequence?
lord, only thing is, my lord, my Order 7, Rule 11 was filed first. Thereafter, my lord, I had filed my written statement. Now, kindly takes up my Order 7, Rule 11, my lord, page 37, paragraph 4. My lord, page 37, paragraph 4.
Wait.
But my case is under Order 7, Rule 11D, where the suit appears from the statement in the plaint to be barred by any law. Now, my lord, I say that, my lord, the averments, my lord, in the statement of the plaint is barred under Section 29 of the Special Marriage Act. My lord, he could not have filed the suit within the period of 1 year. Now, my lord, if your lordship takes a paragraph 4 at page 37. Paragraph 4, page 37. But section 29 imposes a specific bar on filing of this suit.
Okay.
Well, may I place paragraph 4? That it is humbly submitted by a respondent that as per the mandatory desertion, well, that was on the ground of desertion, kindly comes to 2 or 3 lines thereafter. The respondent further submits that the instant proceeding is hit under by the provisions of section 29 of the Special Marriage Act 1954 and hence is premature one, as it is filed on 25th day of January 2021, only after the expiry of 11 months from the date of solemnization of marriage, that is 4th February 2020. But if as per the concerned statute, if the date of registration of marriage is considered as per the mandatory provisions of the appropriate suit, then it is filed only after the expiry of 4 months, as it apparently appears upon the plain reading of the instant suit, for which the respondent further gives leave to adduce all necessary evidence. No, my lord, what I was only praying for is, my lord, section 29, my entire petition is under Order 7, Rule 11D. Order 7, Rule 11D states that where the suit appears from the statement in the plain to be barred by any law. I have shown your lordship section 29, subsection 1, as well as the proviso to section 29. My lord, this suit could not have been filed by the opposite party herein, my lord, until expiry of the period of 1 year. And my lord, so far as the exigency clause is concerned, there is no averment in the plain to that effect, that he is subjected to hardships for which, my lord, he is filing the suit within 1 year, and that also requires, my lord, a satisfaction of the court. If the court is satisfied with the exigency, court can permit him to file the suit within 1 year. So, my lord, what I was only praying for is, my lord, may I serve a copy of the revision application upon the opposite party and the suit state. That is my limited prayer, my lord, at the motion stage.
Awesome. The civil revisional application under Article 227 of the Constitution of India has been filed by the petitioner challenging order number 18 dated 14th May 2024, passed by learned Additional District Judge, First Court Siliguri, in matrimonial suit number 385 of 2021, within bracket matrimonial suit number 385N. 385 or 2021, ঠিক আছে, 10 আর দাও দাও। 2021, rejecting the prayer of the petitioner under Order 7, Rule 11D, or read with section 151 of the Code of Civil Procedure, hereinafter referred to as the Code. The brief fact of the case is that the opposite party husband filed a suit for divorce registered as mat suit number 385 of 2021. Stop. The petitioner wife entered appearance and filed an application under Order 7, Rule 11, within bracket D of the Code, for rejection of the plaint on the ground that the suit has been initiated within a period of 1 year. The application of the petitioner for rejection of the plaint was rejected by the learned trial court. Hence this revisional application. Mr. Shivaji Kumar Das, learned advocate for the petitioner, submits that as per provisions of section 29, submits that the marriage between the petitioner wife and the opposite party husband was at first solemnized on 4th February 2020 and was registered. This registration was under which act? এটা কি চলছে? Registered under the Special Marriage Act. এ কি হলো? On 20 September 2020. Marriage was registered under the Special Marriage Act. Special, huh? Special Marriage Act. Special Marriage Act. On this, the suit for divorce was filed by the opposite party husband on 25th January 2021 within a period of 1 year. Such marriage. Section 29 of the Special Marriage Act 1954 provides that no petition for divorce shall be presented to the district court unless on the date of presentation of the petition 1 year has passed since the date of entering the certificate of marriage in the marriage certificate book. The petitioner on such ground filed an application under Order 7, Rule 11 within bracket D for rejection of the plaint. Which was turned down by the trial court. The provisions of Special Marriage Act as aforesaid clearly puts a bar to filing suit prior to expiry of 1 year. 1 year from the date of entering in the marriage register book. In view of his above submissions, he prays for stay of the In the petition under Order 7, Rule 11D, read with Section 151 of the Code, the petitioner has referred to Section 29 of the Special Marriage Act, which provides that no petition for divorce shall be presented to the district court unless at the date of presentation of the petition 1 year has passed since the date of entering the certificate of marriage in the marriage certificate book. It is found that the marriage under the Special Marriage Act has been registered on marriage by and between the parties has been registered under the Special Marriage Act on 26th September
26 September
2020, and the suit for divorce has been filed on 25th January 2021. In view of the provisions under Section 29 of the Special Marriage Act, this court finds that an arguable case has been made out by the learned advocate for the petitioner. Accordingly, the revisional application is admitted. There shall be stay of all further proceedings in matrimonial suit number 385 of 2021, pending before learned additional district judge, first court, Siliguri, Darjeeling, for a period of 4 weeks or until further order, whichever is earlier. Parties shall be at liberty to pray for variation modification under vacating of the order upon notice to the other side. Petitioner is directed to serve copy of this application along with annexures upon opposite party through registered speed post with acknowledgement due and file affidavit of service on the returnable date. Let the matter appear before the next available circuit bench.
But I'm grateful.
The Passover was come.
Please, my lords, in item 23, my lords, I beg to appear again, my lords, for the petitioner. My lords, may I only, my lords, point out 2 exculpatory facts here in my lords.
Oh no, 23 again. 23.
23.
May I, my lords, in item 23? Please, my lords. My lords, one very, very crucial exculpatory fact in this matter would, my lords, be at page 15, where, my lords, an intimation is sent. If may I, my lords, draw my lords' attention for a moment at page 15. Here, my lords, the complainant, who happens to be a sub-inspector, has, my lords, highlighted 2 aspects. One, a Swiss passport, and one printout of Indian e-visa, my lords, which was valid from 19th March 2024 to 18th April 2024. My lords, the complainant states, I, Sub-Inspector Aditya Lamba, OC Watch Darjeeling DIB, would like to bring to your kind notice that on 12th April 2024 at about 14:10 hours, one Swiss national, namely Christian Mark Durand, 62-year-old male, son of Francois, resident of Switzerland, Switzerland came to FRRO office, DJB Darjeeling, seeking for a issuance of a permit to enter into Sikkim. If I may, my lords, pause here for a moment and highlight and respectfully submit, my lords, this is a case, my lords, where the petitioner had a valid e-visa to be in India till 19th April 2024. On 12th April, he voluntarily goes to the FRRO office seeking an entry into Sikkim, my lords. This is all at the pretext of an agency which is guiding him all this while. Thereafter, my lords, enter Sikkim. Accordingly, LC 85, Preeti Moktan of FRRO, section DJB Darjeeling, attended to the said Swiss national Christian Mark Duran and asked for his passport and related documents for processing of the permit to enter Sikkim. As per instructions of LC 85, Preeti Moktan, he accordingly handed over his Swiss passport bearing number so and so and one printout of Indian e-visa, electronic travel authorization ETA, in the name of Christian Mark Duran, bearing application ID number so and so, application status granted so and so. Date of issue, my lord, is crucial, 19th March 2024, and date of expiration would be 18th April 2024 to her. Upon close verification of passport, LC 85 noticed the cancellation of arrival stamp by Sonoli LICP on page number 16 of his passport. Finding it strange, LC 85 Preeti Moktan questioned Swiss national Christian Mark Duran regarding his entry into Tibetan Indian territory without an arrival stamp. The Swiss national Christian Mark Duran admitted that he had entered into India through Nepal via Sonoli LICP, but the immigration officials cancelled his entry there and had directed him to take a flight to Delhi from Nepal. He also admitted the fact that he was also denied entry. He again illegally entered into Indian territory through Gorakhpur, Uttar Pradesh by car. On being asked, he failed to produce any documents which proved his entry into Indian. My lords, this is what the investigating officer, I'm sorry, the complainant had to say. What had, my lords, really transpired on the ground is completely different from what the narrative on the last paragraph is. On his visa, my lords, on his electronic visa, he was asked to sit in a bus by his travel agent that you will be allowed to enter India. My lords, there is a check post with one individual at guard. He, under, my lords, a bona fide belief, insofar as, my lords, again, section 50, I will, my lords, draw my lords' attention to 15, under a bona fide belief that he had a valid e-visa. Otherwise, my lords, with great respect, he had absolutely no occasion to otherwise voluntarily go before the FRRO office. He could have himself, my lords, taken the same route back to Nepal. In all this, my lords, he then undergoes a period of incarceration, 2-3 days, my lords, and the charge sheet, my lords, are very crucial. My lords, may please have, my lords, page 23. The prosecution says they do not need to investigate this further. At, my lords, page 23. My lords, the page 23 is an order dated 15th April 24 of the learned CJM Darjeeling, where the prosecution has, my lords, admittedly stated that charge sheet has already been submitted in this case. After completion of investigation, there is no prayer for the prosecution for further investigation or submission of supplementary verification of the genuineness of the Switzerland passport and so on. May I, my lords, may I buttress my case, my lords, squarely on section 15, my lords, this case is different, not at par with other cases, my lords, either where there is an overstay or an individual enters India through an illegal visa, and, my lords, or through a channel which is not bona fide, stays in India and is apprehended by agencies either on road or my lords, an airport or somewhere else. Here, my lords, the petitioner voluntarily, my lords, goes at the risk of reputation, perhaps, my lords, to the FRRO office. Again, yet again, my lords, he is an academician in Switzerland, teaches chemistry. My lords, with great respect, if I may draw my lords' attention to page, my lords, section 15 for a moment, my lords.
Where is the copy of the application that he approached the office for extension?
My lords, that application was not provided. The minute he presented his request, the police officials were summoned and he was handed over, my lords. This is, my lords, the complainant's case himself, and he was pretty much there, my lords, the fact which is unrebutted even otherwise. He was arrested. That is precisely the place of arrest as well, my lords. He was then taken into custody and released subsequently, my lords, on a regular bail to get his visa extended, which is the bail order, my lords, is at page 25.
Now it is extended.
Now it is extended, my lords, with great respect. This order helped him extend his e-visa. He is not allowed to exit, my lords, which he doesn't want to. He would wish to avail all legal remedies, my lords. He is now living in Darjeeling. He is, my lords, a 62-year-old senior citizen with severe ailments. Mother is 90-year-old, my lords, a blind lady. I am happy to place that on record. Otherwise, my friend would be carrying mother's medical record. She's completely, my lords, blind, devoid of any visual faculties. This is, my lords, again, my lords, with great respect, a case where he has traveled, my lords, half of this planet. He is a teacher by profession, academician, never undergone anything. This is the first sort of, my lords, criminal prosecution in his entire life. If, my lords, my statement may be recorded. Even otherwise, my lords, I have expressed instruction. He says if he is willing to, my lords, do anything for Indian students, even, my lords, perhaps render his financial assistance, if we could do anything insofar as academic sector is concerned. This is, my lords, one of those cases, my lords, where he's really struggling with his mental health. In fact, my lords, what I am given to understand by the petitioner, the minute he sought an extension, he was requested to be seated there in the FRRO office. To his shock, he was then taken into custody. And, my lords, this is a very unfortunate case where these travel agencies, just to, my lords, save money and cut down their travel costs, are making these individuals travel in groups. He was traveling in a group, my lords, a Matador vehicle. This is precisely what transpired that day. Had he been sent back physically, he would not have an occasion to even enter India on a valid electronic visa, which is, my lords, again confirmed to be a valid electronic visa, my lords, in all this while.
Now, what is the process of getting it extended?
My lords, the process in this case was a little different. We had relied on this order. He made, my lords, a few visits to the FRRO office in Darjeeling on the premise of this order and requested them, because, my lords, the hotels would require his electronic visa or some sort of a valid visa to allow him to stay. All this while, my lords, he was at the mercy of the Embassy and Consulate General of Switzerland, and they were also trying to, my lords, accommodate him. With great respect, my lords, this visa extension was very necessary for him to then find a suitable accommodation. In the meantime, my lords, he is very devastated with this entire episode. And, my lords, undertake to abide with any condition, my lords, with the situation being he is totally, my lords, in all good faith has acted upon the express instructions of his tour and travel agency.
Okay.
I'm sorry.
From the complaint, my lord, itself, it is evident that though they are saying there is a valid visa, my lord, there might be a valid visa, but even after having a valid visa, my lord, there are certain criteria, my lord, every country imposes while a foreigner intends to visit his homeland. Now, my lord, while entering India and while granting him visa, my lord, there was certain.
Foreigners act on yes. Yes,
Lord.
Oh, you have. Okay.
But there were certain conditions that, my lord, he has to enter India through a specific route. Now, my lord, while he was trying to enter India, seeing his visa and the conditions therein, my lord, the immigration officials denied him entry from that checkpoint. And he was asked to come through the proper checkpoint as he should have come. And, my lord, what he does, he, my lord, again comes to India through a different route without going through the process of immigration. Now, my lord, when he enters India and when he goes to the office of the concerned.
What is the difference? He was not allowed immigration through a particular check post.
Yes.
But he can be allowed through another check post. Is it?
My lord, as per the conditions of visa, my lord. So that was the condition of his visa.
Where is that? You have the.
My lord, in the complaint itself, it is written, my lord.
May I answer my lord's query, if I may? I have done, my lord, extensive research, if I may assist.
Now,
I will come to you.
Oh, I'm so sorry, my lord. I'm so sorry.
My lord, in this second paragraph of the complaint, not second, my lord, fifth paragraph, second from the bottom. My lord,
Swiss national.
The Swiss national, yes. It says the Swiss national Christian Mark Durand admitted that he tried to enter into India through Nepal via Sonauli LICP, but the immigration officials cancelled his entry there and had directed him to take a flight to Delhi from Nepal. He also admitted that after he was denied entry, he again illegally entered into Indian territory through Gorakhpur, Uttar Pradesh by car. On being asked, he failed to produce any documents which proved that his entry into Indian territory was legal. He was given ample time and scope in this regard. On further consultation with FRRO, Kolkata, the officials there confirmed the fact that there were no records with them regarding entry of Swiss national Christian Mark Durag into Indian territory. So, my lord, whenever a foreigner intends to enter India, my lord, he has to go through the process of the immigration. And my lord, once he goes through the process of immigration, my lord, it goes updated into the data to the Indian authorities as well as to the Swiss authorities, my lord. Now, my lord, he does not do that. And, my lord, when he enters India, so, my lord, he contravenes the provisions of the Foreigners Act. So, my lord, under that circumstances, my lord, the instant prosecution was started. My lord, it is admitted also by them that there is a violation of the Foreigners Act.
But the date on which the complaint has been lodged,
my lord,
it says that e-visa is valid till 18th April 2024.
Yes.
So what was the illegality or violation done by this person?
My lord, the process of entering India and the process of going through the immigration process, my lord.
Okay. If he goes through a flight, then he has to pass through immigration.
Yes.
In the airport.
Yes.
Okay, he has just.
Yes.
Okay, scaled that and he entered through Gorakhpur.
Yes.
That is the violation.
Yes.
Okay.
Now, my lord, here the charge sheet has been filed. My lord, the matter is ready for trial. My lord, they are also admitting that yes, there is a violation on the part of this accused person. So, my lord, they have their remedy before the trial court. If they want to plead guilty, my lord, they can do so. So, at this stage, my lord, this is not a fit case for quashing the proceedings, my lord. So, that is my humble submission before your lordship. Let them, my lord, avail their remedy before the learned trial court.
Yes.
May I, my lords, briefly rebut my friend and colleague? My lords, my friend has a valid point insofar as modus operandi and mode of entry into India is concerned. What had, my lords, really transpired? Now, my lord, there are linguistic barriers. He speaks only French and German. What really transpired, my lords, my colleague is, my lords, perhaps treating the complaint as a confession that he had entered through Nepal and done something of that kind. My lords, that was not the case. In fact, what had really transpired, my lords, his visa was only stamped. Then he was made to sit in the same bus where other foreigners have also entered, my lords. He is not a trained militant who would find a way into India through a different route, which is, my lords, in fact, the case, fact of the matter. He entered the very moment his visa was stamped. Now, my lords, due to linguistic barriers and the fact that they travel in group, other individuals were also sitting, my lords, with great respect, these are porous borders. They are made to enter India in a crowd or even in a bus. Nobody checks. Now, he should have perhaps triple checked, but my lords, section 15 thereafter, my lords, come to his rescue. Section 15 unequivocally makes it very clear, my lords. Protection of persons under this act. No suit, prosecution, or other legal proceedings shall lie against any person for anything which is in good faith done or intended to be done under this act. My lords, may I draw my lords' attention to section 15. I am being prosecuted, my lords, under section 14. Section 15, my lords, of the Foreigners Act. No suit, prosecution, or other legal proceedings shall lie against any person for anything which is in good faith done or intended to be done under this act. Even, my lord, section 14 and the bare perusal of section 14, under which I am, my lords, presently being prosecuted, is, my lords, not even remotely attracted insofar as facts and circumstances from the bare perusal of the charge sheet and the FIR is concerned. Complainant admits that I was at the FRRO office seeking extension or entry into Sikkim through a valid permit, my lord. There cannot be any other plausible belief that an individual who has illegally entered India with a guilty mind, my lord, actus reus and mens rea, would now go to Sikkim FRRO, Darjeeling FRRO office seeking extension of his visa. Section 14, my lords, under which I presently face prosecution, is also very distinct. Section 14, my lord, says contravenes the provisions, remains in any area 14A for a period exceeding for which my visa was, my lords, valid till 19th of April. Does any act in violation of the conditions of valid visa issued for him for his entry and stay in India? Here, my lords, may I only respectfully add, e-visa are valid for entry through airports alone. He had a valid e-visa. Now, my lords, with great respect, had the authorities sent him back physically, which was in fact, my lords, not the case. He was again in a group of individuals, only stamped something which he interpreted again, my lords, the German linguistic individual, a 62-year-old, that the entire group is getting something stamped and is being sent back. Please, please.
I understand that he had a bona fide intention, but somehow he was in a bus through Gorakhpur. If it is admitted, for sake of this argument, that it is admitted that he has gone into India, he has not passed through the immigration officials and he has entered India through that check post, right?
My lords, he had also entered, with great respect, may I just clarify, he also, please, my lords.
Please, sir.
Please.
Now you say that he has a bona fide that he applied for seeking permission, that is in the complaint itself, and you are protected by 15.
Please.
Tell me what prompted him to take that check post and not availing of a flight.
My lords, in fact, this was one question which I put forth to the petitioner in my detailed meeting, even with the embassy officials, my lords.
2 p.m.
What
sir.
Please, lords, please, grateful.
Who? Huh? Mr. Chaudhary, come
My
at
lord,
2.
my lord.
I'm so grateful, my lords. Thank you. Thank you.
The civil divisional application for with bearing number CO 32 of 2024. It's fixed tomorrow for hearing. Lordship, a CAN application is also is required to be filed because the stay order will be expired. Lordship, I'm praying for to leave of the court so that it may be filed today, Lordship. Today itself, Lordship.
Not the time.
I have the CAN application here with me, Lordship.
Mention tomorrow.
All right, Lordship.
Mention tomorrow.
Right.
This is the application for extension.
Yes, application for extension. We have the matter fixed tomorrow. I mean, your Lordship said it. All right,
Mention tomorrow. Yes.
Please, my lords. My lords was pleased to put forth, my lords, a query prior to my lords lunch vacation, lunch break, my lords. My lords, all this transpired, my lords, with great respect on 10th of April 2024. My lords, Sanoli to Gorakhpur is around 1.5 hours. My lords, the petitioner had procured, my lords, the package. They do, my lords, the package which includes food, travel, sightseeing, and all those visits. Now, my lords, perhaps they did not wish to return his money. He was requested that he will be taken from a different location since the authorities here are done for the day. On 10th April itself, my lords, the petitioner was taken to this location, which is 1.5 hours away from this checkpost. And then he was, my lords, taken to India, welcomed there, my lords. We don't know how they did it. This is not a, my lords, of with great respect, an occasion where he was waiting for a day or two to then trespass into India through a different route. All this, my lords, respectfully transpired on 10th April, around that time itself. And all this while, my lords, the petitioner was under a bona fide belief that his visa is still valid till 19th of April. This all happened on the very same day, very moment, my lords, without any gap or break, at the behest of the agents who were traveling with him. In my lords, it's a mini bus kind of, my lords, the air-conditioned mini bus. To
Yes.
respectfully answer, my lords. My lords, we did a lot of research. This is unlike, my lords, any other case where an individual has himself turned himself up for an extension. In most of, my lords, my research on this subject matter, which yielded that there have been instances where people have been apprehended, either it's a drug case or something where police authorities have come into notice, where they have gone to an airport or they are trying to sneak out of India. Well, it's a state-of-the-art case where an individual has himself voluntarily gone to the FRR under a bona fide belief. Well, he's a chemistry school teacher with, my lords, a blind and ailing mother. There was no intention at his BS, my lords.
Any other thing has surfaced during the investigation, save and except that there was a violation of immigration?
My lord, in order to answer that, my lord, I require the case diary. I do not have the case diary. My lord, only on the basis of the documents supplied by them, my lord, I have argued the matter. But, my lord, from the documents.
What you do,
my lord,
produce the case diary tomorrow.
tomorrow, this is Darjeeling. My lord, Darjeeling, there is a, my lord, I have heard.
When can you produce? Day after tomorrow on 20th?
Day after tomorrow, I'll try, my lord. I'll pursue with the office, my lord, so that the CD comes.
So he is not having the case diary on 20th. Bishnujit Babu, on 20th, it is topic.
I'm so highly obliged, my lords.
Mr. Heard the learned advocates for respective parties. Mr. Arjun Chaudhary, learned advocate for the state, seeks to the case diary. Let the matter appear on 20th June 2023 at top. Hearing top, hearing means top.
I'm so highly obliged, my lords. I'm so grateful for a patient hearing, my lords.
Yes, thank you.
Grateful.
Yeah. Grateful.
Make sure that it is produced on 20th, so that this can be launched.
My lord, item number 4, I'm giving the affidavit of service. Let the matter be posted for tomorrow or day after tomorrow, whenever your lordship.
Then you file on that day?
No, I'm filing it today, my lord. Keep it tomorrow because this is ultimately a appeal with regard to reduction of quantum of sentence. It's a mercy petition, my lord. Nothing. There is no scope of argument in this matter.
Fine.
Yes, my lord.
Reduction of fine.
No, sentence and fine both. Foreigners Act, my lord.
How many years?
The minimum limit.
Sentence has been imposed.
3 years.
3 years imposed.
3 years and 30,000. The minimum is, my lord, 2 years and 10,000. It's after all a mercy petition, my lord, if my lord can.
And then the other side is required.
Yes, my lord, I have served him. They will be appearing.
Who is appearing for the state?
My lord, I do not have any idea with regard to this. We have served it. keep it tomorrow, my lord. It would be, it's a humble request from my side.
But then the other side is required in this case. So what you do is,
Yes, my lord.
I'm fixing the matter tomorrow or day after tomorrow, whatever.
Yes.
In the meantime, you find out who is for the state so that the matter can be disposed of.
My lord, today I'll find it out.
Huh?
The keep it-
Section 5 টা তো dispose করে দেওয়া যেতে পারে কিন্তু admit করে আবার সেই paper book এইসব direction দিতে হবে
Because the petitioners have pleaded guilty in this matter.
Oh, you have pleaded guilty.
Yes. I am not in argument of the facts. It is just a mercy petition.
Ask the learned advocate for the state to remain present. Huh?
Tomorrow?
For the state. Tomorrow?
Tomorrow. My
Huh? Huh? Tomorrow কি অবস্থা দেখুন তো ডায়েরি tomorrow.
My lord,
Keep that.
my lord, I'm grateful, my lord.
Tomorrow we'll see.
My lord. My lord, time for the petitioner. My lord, in this revisional application, I am challenging the order passed by the executing court. Order passed by the executing court dismissing my execution application on limiting on the point of maintainability. Despite the liberty was granted by the High Court to file a fresh execution petition before the executing court. The learned court below was sitting as a court of appeal or revision against the order of the High Court. I will come to the order impugned. Before that, I will narrate the facts of the case in nutshell. Your petitioner was a auction purchaser of a standing timbers which was held in the year 1972-1973 by the Kalimpong Forest Division. Being H1 bidder, the agreement was entered into between your petitioner and the forest department to cut and fell the trees and season it and transport it from the forest department. There was a certain time stipulated in that agreement. There were 7 lots of timbers, 7 lots of timbers in the agreement. 5 were already transported. For 2, there was a specific time to transport, but due to hilly terrain, that in the month of rainy seasons, he could not transport the timber logs. He made an application for extension of time. Similarly placed, other bidders were extended. He was denied. To that effect, he filed a civil suit before the learned court below in the court of learned subject Darjeeling. Thereafter, his plaint was returned in the year 1995. Thereafter, he presented the plaint before the proper court. The suit was dismissed and he preferred an appeal against that order. The appeal was decreed in his favor in the year 2005. He put the decree into execution in 2005. The executing court decided the matter in the year 2018, stating that the decree is inexecutable. Only on one count, that the subject property of suit property is no more existing in the suit premises. So your decree becomes inexecutable. Against that, he preferred an appeal before the appellate court.
No. What was the ground for rejection of the execution? Again?
My lord, kindly come to page number. Page number 91. This is the present order of execution, which dismissed my execution application. There was no application of maintainability on record. There was no section 47 application on record. Page number 91. Today is fixed for passing order. Both parties filed Hazira. The petition on maintainability point has already been heard. There was no maintainability petition on record. Which petition was heard? That was unaware of. It was argued by the learned advocate for the judgment debtor that the execution matter relating to OC suit number 17 of 1999 has already been disposed of by the then presiding officer of this court by order dated 18/8/18. In the said order, it was stated that the OC execution number 03 of 2007 has been disposed of on contest and the decree passed in OC 17 of 1999 cannot be executed. This OC number is also mentioned as wrong. It would ought to have been OC Appeal 22 of 1999.
Against the state execution order, OC Appeal 4 of 18 was filed before the learned district judge Kalimpong. It was ordered in that case that the appeal is dismissed on contest and the OC execution number 3 of 2007 is not legally maintainable as the suit is not legally maintainable on the ground that the claim did not contain any schedule in respect of immovable property. My lords, this standing timber is not an immovable property. This is a movable property. And this has already been discussed by the constitutional bench when the standing timber would qualify as a movable property and when it will be qualifying as a immovable property. I have a judgment to that regard. In that support, I will place the judgment that it is a immovable property and no schedule is required under Order 7, Rule 3 of the Code of Civil Procedure in cases of movable property. It was also mentioned that the decree which were drawn did not contain any schedule of immovable property and also the description therein. The decree does not mention any schedule of the property in case of immovable property, and if it is mentioned only in the ordering portion of the judgment, then it is not possible for the bailiff to execute the decree as the bailiff is not legally bound to see the judgment and execute decree. The bailiff will not be able to execute a decree if there is no schedule mentioned as per the relief granted in the decree itself. Therefore, it is seen from the previous order that the execution case was set at rest by OC Appeal number 4 of 18 passed by the learned district judge Kalimpong. It was ordered therein that the decree OC case number 17 of 1999, there is again wrong mentioning of case number, cannot be executed as there was no schedule mentioned in the decree. The learned advocate for the decree holder stated that the Honorable High Court in WPA 705 of 2021 has ordered that the decree holder has been given a liberty to make a fresh proceeding for execution. Accordingly, the instant execution case has been filed before this court. From the materials on record, it is seen that the decree passed by the learned appeal court, and also in the decree passed by the civil court, there is no mention of any schedule in the suit. Moreover, when the judgment debtor preferred an application under section 47 claiming that the decree passed in OC Appeal number 22 of 1999 was not executable as the decree was silent in respect of the schedule, the same was dismissed on contest by the order dated 2010 being order number 47. It is the basic principle of law that in execution of a decree, the executing court is guided by the decree and relief awarded by the court delivering the judgment. Looking into the decree, it is seen that there is non-availability of the subject matter. That the tree is in question as per the report of the bailiff concerned. And an executing court cannot go beyond the decree already passed. This view was also held in previous execution case. The present scenario has not changed since then. Till date, the decree is null regarding the schedule and it has not been corrected. From the application of the present education case, it would out to have been execution case. It is seen that the decree holder has claimed an amount of 10 crore 7 lakh 61,300 10 crore 76 lakhs 13,197.48 rupees against the judgment debtor. Not this claim does not appear in any portion of the decree in OC Appeal number 22 of 1999. The entire writ was beyond the decree passed and is having no comparison with the judgment dated 29/10/2005. My lord, the learned court below was acting as a court of appeal against the order of the High Court. It is stating that the entire writ was beyond the decree. High Court was of the session of the matter and High Court granted me a liberty to file a fresh execution petition. The learned executing court, without going into the merits of the case, without exploring the possibilities to execute the decree, the petitioner is already into the litigation for 5 decades. He is an octogenarian person. Despite having decree in his favor, he is not unable to enjoy the fruits of the decree. And altogether, this period of between 2007 to 2024, the learned court below altogether ran in a wrong premises that this property ought to have been a immovable property. Rather, it would be a movable property. In case of movable property, schedule of the property is not required to be filed along with the plaint. If the
What was the order passed in the previous execution case?
My lords, kindly come to page number 70. My lords, I pray for apology. That order is a bit illegible. I have a true type copy. And I seek the liberty to
for filing supplementary affidavit to bring this true type copy on record. Lordship, page number 70, last paragraph is important. There is no mention of any schedule in the decree passed by the learned appellate court and
Wait.
all.
Where is the order of the High Court?
At page 81. Liberty is, however, reserved to petitioner to take out fresh execution proceedings for execution before the learned civil judge junior division at Kalimpong. Third paragraph. In furtherance to this execution application was made, which was rejected. The question of maintainability does not arise at all after the liberty has been granted. It ought to have been heard on merits.
You not praise the writ petition?
Yes, Lordship. Honorable Justice Rajasekhar Mantha was of the opinion that you not press the application. I am giving you the press liberty to carry out the press execution proceeding before the. And the provision of Order 21, Rule 31 also highlighted by the Honorable Justice Mantha in that regard.
Order?
Order 21, Rule 31. I have
Where it is mentioned? Where it is mentioned?
No, it is not mentioned in the order. It was verbally stated by the Honorable Justice Mantha that you have a remedy under Order 21, Rule 31. Even in case of there is no schedule and no alternate remedy has been mentioned.
No, at that stage, the previous execution was disposed of.
Yes, it was disposed of, stating that the decree is inexecutable. And the suit property is no longer available in the spot. as per the report of the bailiff. The bailiff also reported to the court that whether the property was lost or removed, he cannot ascertain. Whether the property which is lost, and I have a decree in my favor, where my all of my prayers regarding permanent injunction, mandatory injunction was granted in my favor. If the suit property is lost to anyone, whether the decree holder would be deprived of the fruits of the litigation. That is the moot question.
But the execution case has been disposed of or dismissed on the ground that you did not mention in the schedule of your petition about the which of the properties to be executed.
Lordship, I am placing one judgment. First, I have to overcome that this is a movable property. In case of movable property, how the decree needs to be drawn, that is stated under Order 20 Rule 10, and how it needs to be executed, it has been discussed in Order 21 Rule 31.
Where is your plaint?
Plaint, I have annexed at page number 27, annexure P2.
It's 27.
Page 27.
Suit for injury compensation.
34 is my prayers. Page number 34. Prayer A is permanent injunction restraining the defendants from removing and or selling the trees purchased and felled by the plaintiff with consequential relief of declaration that the plaintiff has right to fell and remove the trees purchased by him and also already felled by him. Prayer B, mandatory injunction directing the defendants jointly and severally to grant extension of sufficient and adequate time required for felling and removing the trees of the two lots in the suit. And prayer is any other reliefs. The suit was decreed in my favor, all of the prayers were granted.
What is the, where is the amount?
The amount was not
to execute.
The amount was not given in the plaint.
Then your entire action is wrong. You have not claimed the amount and you are asking the executing court to execute a decree.
Lordship, I will highlight just one provision. Order 21, Rule 31. In case
whatever, suppose a decree has been passed.
Yes, Lordship, I found
for permanent injunction by the learned district judge in appeal. So you execute that.
But the suit property is no longer present in the.
No, I'm asking you. As a prudent officer of the court, how you will execute that? Tell me. And in your petition, you say that 10 crores of money is due, which is to be executed. How do you assess that?
That was a report.
There has to be some facts upon which you can take action. You have prayed for permanent injunction. Court dismissed your suit. The appeal court allowed your decree. So you are enjoying a permanent injunction. But so far as the 10 crore claim is concerned, how could the court assess and grant a decree in your favor?
In that regard, I annexed expert report.
In
and
the execution proceedings,
value.
was any application filed? This is the fact.
But in this phase execution application, I will bring on record.
Now you will bring on record. Now every time you are submitting that such and such decade has passed. You have submitted. How many decades have passed?
5 decades.
5 decades. Now you will bring on record the fact that 10 crores are due.
Lordship, on that premise, the court was of the opinion that this is an immovable property.
The High Court at the time granting you liberty did not opine anything regarding the execution proceedings, save and except granting you a liberty to file an application. That you have filed.
Yes, sir.
The court was not directed to decide something other than what was decided in the previous one.
Yes.
It is also a fact that there is no schedule.
No schedule.
So where do you stand after 5 decades?
Lordship, in case of standing timber, it qualifies as a movable property. In case of movable property, there is no schedule required to be appended to the plaint. And how the decree of movable property needs to be executed, it has been discussed under Order 21, Rule 31.
So you did not state anything about the movable. Suppose you are claiming some injunction regarding a vehicle.
Yes.
Huh? You will not state the number of the vehicle, nothing. And you directly come to order 21 rule 31.
But in plaint, it was stated 166 number of trees were about to be filled down and transported.
Directly you cannot execute. There has to be something in the plaint.
Lordship, non-availability of the timbers came to my knowledge during the execution proceedings. This plea was never taken by the judgment debtor during the pendency of the suit. Certainly, when the decree was put into execution, they sell the trees, and I will be deprived of my fruits of the decree. This can't be allowed. If this is allowed to happen, then no decree holder will be able to enjoy the fruits of the decree. In that regard, there is a judgment of the Supreme Court. Recent judgment. Though this is a judgment pertaining to immovable property, but the ratio will apply.
Paragraph?
Paragraph 28, 29, 30 and 31.
Twenty-eight.
In Samir Singh versus Abdul Rab, this court again observed that executing court has authority to adjudicate all questions pertaining to right, title, or interest in property arising between the parties, including the claim of a stranger who apprehends disposition of the immovable property. This is provided to avoid multiplicity of proceedings, and if a court declines to adjudicate by stating that it lacks jurisdiction, that by itself would occasion failure on part of the executing court to exercise the jurisdiction vested in it. In most recent judgment in Jini Dhanrajgir versus Sibu Matthew, the legal position has been reiterated that Rule 97 to 103 of Order 21 of CPC provide the sole remedy both to the parties to the suit as well as to the stranger to the decree put into execution. In view of the settled proposition, as noted above, it was the duty of the executing court to issue warrant of possession affecting physical delivery of the suit land to the decree holder in terms of the suit property, and if any resistance is offered by any stranger to the decree, the same be adjudicated upon in accordance with Rule 97 to 101 of Order 21 of the CPC. The executing court could not have dismissed the execution petition by treating the decree to be inexecutable merely on the basis that the decree holder has lost the possession to the third party or encroacher. If this is allowed to happen, every judgment debtor who is in the possession of immovable property till the decree is passed shall hand over the possession to the third party to defeat the decree holder's right and entitlement to enjoy the fruits of the litigation, and this may continue indefinitely and no decree of immovable property can be executed. So there was a provision discussed 97 to 101, but in case of movable property, the ratio will apply. Order 21 Rule 31 will come to rescue me. May I press the provision, Order 21 Rule 31? Decree for specific movable property, where the decree for any specific movable or for any share in specific movable, it may be executed by seizure if practicable of the movable or share, or by delivery thereof to the party to whom it has been adjudged, or to person as he appoints to receive delivery on his behalf, or by detention in civil prison of the judgment debtor, or by the attachment of his property, or by both. Subsection 2, where any attachment under sub-rule 1 has remained in force for 3 months if the judgment debtor has not obeyed the decree and the decree holder has applied to have the attached property sold. Such property may be sold out of the proceeds and out of the proceeds, the court may award to the decree holder in cases where any amount has been fixed by the decree to be paid as an alternative to delivery of movable property, such amount, and I stress upon this line, and in other cases, such compensation as it thinks fit, and shall pay the balance, if any, to the judgment debtor on his application. The executing court has well within its power to grant me compensation if the decretal property is no longer available in the site. And I have claimed the compensation. It is upon the executing court to pay me what it deems fit and proper.
Such compensation is the balance such property may be sold and out of proceeds. Order 30, order 21, rule 31, you have read, it relates to attachment of the property.
How the decree of specific movable property will be executed, that has been read in order rule 31. By attaching judgment debtor's property. And
Have any decree been passed for delivery of that failed trees? Did you pay for recovery of those amounts? Those failed trees, which are movable, as you say.
Those trees are movable.
Have you prayed in this suit that you hand over those possession of those?
Yes. Lordship, kindly come to page number 34. Page number 34 of my application. These were my prayers. Permanent injunction restraining the defendants from removing and or selling the trees purchased and felled by the plaintiff, with consequential relief or of declaration that the plaintiff has right to fell and remove the trees purchased by him and also already felled by him. Number B, mandatory injunction directing the defendant jointly and severally to grant extension of sufficient and adequate time.
You serve notice to the other side.
Yes, Lordship.
This revisional application has been filed, challenging order dated the motion is, challenging order dated order number 15 dated 24th April 2024, passed by Learned Civil Judge Junior Division Kalimpong, disposing of the execution case of holding that the same is not maintainable. Mr. So-and-so, learned advocate for the petitioner, submits that the plaintiff petitioner filed a suit for injunction with compensation relief and mandatory injunction, being OC suit number 17 of 1995, which was dismissed. With a prayer for permanent injunction.
And injunction being
Hmm. being OC suit number one,
Yes, 17/99 with the dismissed.
which was dismissed by the Civil Judge Junior Division Kalimpong.
White order dated
This order dated
18 August 1989.
2018.
18 August
18
1999. White order dated. August 1999.
The dismissal of such suit was assailed in appeal before the
District Judge Darjeeling ADJ Second Court.
District Judge Darjeeling ADJ Second Court.
Yes.
How is this rank? Either he is a district judge or ADJ.
Additional District Judge Second Court. Additional District Judge Second Court. Darjeeling.
Which was assailed in appeal before the District Judge Darjeeling in OC Appeal number 22 of 1999. The said appeal was heard and disposed of by Additional District Judge Darjeeling. Stop. In the appeal, the order and judgment of dismissal of the learned trial court was set aside and decree was passed in favor of the petitioner. In order to execute the decree, the petitioner filed an execution case being OC execution case number 3 of 2007 before the Civil Judge Junior Division Kalimpong. Which was dismissed which was disposed of, holding that the trees in question are not existing and the decree passed cannot be executed since the same is not executable one. Why a writ petition was filed challenging that?
Writ petition was filed for claiming adequate compensation.
Did not challenge that order.
Lordship?
You did not challenge that order in any division.
No. Since the liberty was granted.
The petitioner preferred a writ petition being 700 being WPA 705 of page number
81. 705 of 2021.
for adequate relief. WPA was filed for adequate relief.
Adequate compensation. and
Adequate compensation.
Ancillary relief.
2021 for adequate compensation. The said writ petition was disposed of, giving liberty to the petitioner to file press proceedings for execution before the learned Civil Judge Junior Division at Kalimpong. Pursuant to such order, the petitioner filed an application for execution, being civil execution case number 1 of 2022, which was disposed of on the ground of it being not maintainable since the decree is not executed. Having heard the learned advocate for the petitioner, this court finds that the opposite party needs to be heard in the present application. Will the Forest Department?
Yes, Lordship. West Bengal Forest Development Corporation Limited.
Accordingly, petitioner is directed to serve copy of this revisional application along with its annexures upon the opposite party to registered speed post and on due and file affidavit of service on the returnable date. Submission after he also to buttress his contention and relies on the decision of Honorable Supreme Court asked in data. Service. Next.
Deeply applied.
There were options for the plaintiff to file a section 47 application if those was not paid for in the execution process that was there. He filed it.
No, there was no application on that. Straight away, my application was dismissed on the point.
Anyway, there is a prayer for see. Okay, sir.
Lordship, I am appearing on the behalf of the petitioner. Lordship, this is an application under section 24 of CPC. 31.
Huh?
What, my lord? This is application under section 24 of CPC, my lord.
24.
My lord, the petitioner is living separately with his husband. My lord, the petitioner filed application under 31A.
Application will be served upon on the counsel for the petitioners.
My lord, the petitioner have two minor daughters residing with her. She took care and custody of that both the
Who is
minor
for
children.
the opposite party.
Have already been served and they have filed the affidavit in opposition also. Right now they haven't appeared.
Opposition you have given.
My
You have
lord.
served the copy.
My lord. And they have submitted the affidavit in opposition also. Upon us. But perhaps they have served us.
Sudeep Guha. You are the wife.
I am the, yes, my lord. I am for the petition. The wife is the petition.
Not today.
My lord, tomorrow is not possible, my lord. I have some personal difficulties.
What
If you
difficulty?
my lord, my that uncle has died now.
Oh,
tomorrow.
sorry. Day after tomorrow?
Day after tomorrow.
Date 20th.
Grateful.
Up to 2 na?
For the OP, my lord, against the order passed by the trial judge under section 24 of the Hindu Marriage Act,
they prefer this application and we have appeared. And since then they are avoiding take part. Our appearance may be noted.
Petitioner is not appearing.
Petitioner is not appearing since last couple of days, my lord.
Tomorrow. Calcutta.
Our appearance may be noted, my lord. আচ্ছা না আমাদের অ্যাপিয়ারেন্সটাকে নোট করা যাবে?
My lord, I beg to appear for the petitioner. And for the respondents, the learned counsel will proceed through video conferencing. My lord, this is an application by the petitioner under challenging the order passed by the learned court below in an application under Order 7, Rule 11. My lord, before going into the impugned order, my lord, I need to brief the facts of this
You are
case.
Defendant.
My lord,
You are the defendant in this.
I am the plaintiff and they have filed a counterclaim in my suit, my lord. And I have challenged the counterclaim by way of an Order 7, Rule 11. On two grounds, my lord. One is barred by law and second is lack of cause of action, my lord. So, my lord, before going into the impugned order, my lord, I need to brief the facts of the case. My lord, the plaintiff in the year 2018 purchased the suit property, my lord, from the constituted attorney of one Mr. Mani Kumar Shubba. In the year 2018, my lord, kindly comes to page number 19 of my application. My lord, this is very important because Mr. Mani Kumar Shubba, he was a member of parliament serving at the Lok Sabha, my lord. And his details were recorded by the Sansad in a digital form, and that I have annexed because that is very essential for adjudication of this case, man. At page number 19, Annexure A. My lord can see list of members list of members, Lok Sabha, House of People, Shri Moni Kumar Subba. My lord, kindly comes to the personal details wherein marital status is given, my lord. Towards the end, my lord, marital status. Married, and the name is Srimati Jyoti Subba. And this name needs to be noted because this is giving the entire suit and subsequently, what happened? A power of attorney was registered before Delhi, the sub-registrar Hoshkas 5 at Delhi, my lord. And an attorney, Mr. Narendra Limbu, was constituted to be the attorney. I have annexed the said power of attorney, registered power of attorney at page number 22 onwards, wherein Mr. Manikumar Subba has given an attorney to sell and do anything regarding that property. Subsequent to that power of attorney, my lord, a deed of conveyance was registered wherein the attorney of Mr. Manikumar Subba executed a deed in favor of the plaintiff petitioner herein. Now, my lord, in 2019, subsequent to the registration of the deed, exact date, my lord, I have stated in my para number 8 that on 27/5/2019, at page 6 of my application, para 8, Mr. Manikumar Subba died intestate on 27/5/2019. That means
No, para 8 of your which application?
my original application in my pleadings.
Yes, died intestate.
Died intestate on the date, my lord.
Yes.
27/5/2019. My lord, kindly sees Annexure C. That is starting at page number 29. This is my deed of conveyance. My lord, the date of registration is 20th November 2018.
So he dies on
Page number 29.
19 he died.
Yes, my lord.
18 this has been executed by Mr.
Executed.
Limba.
by the attorney.
Attorney.
Yes, my lord. But my lord, since the deed was registered by an attorney, but the entire sum consideration that was agreed between the parties, the sum of rupees 1 crore, was transmitted from my bank account to the account of Mr. Manikumar Subba himself, not to the account of the attorney. So that 1 crore, it's been transferred in two transactions, my lord. One is that page
This
number
is the
53.
1 crore is the total transaction of the sale process.
Sale proceedings, my lord. At page 53, I have annexed the bank statement of the plaintiff, wherein, my lord.
Page 53.
53. Wherein 1, 2, 3, 4, 5, 6, 7. My lord, kindly see at the 7th withdrawals, 7th column, 25 lakhs. 17/8/2018, 25 lakhs, CLG Mr. M.K. Subba, SBI. A check was given, my lord. 25 lakhs and page number 54, my lord. Next page.
No, this transaction dated.
Transaction dated is, my lord, 17/8/2018. Check number 792025. And towards the end, my lord, can see 25 lakhs.
Could you just give me the serial number? 1, 2, 3, 4, 5.
4, 5, 6. 7th transaction, my lord, wherein from 72 lakhs, my dear, balance was
72 lakhs
reduced to 42 lakhs.
46,805.
My lord?
72 lakhs 46,805 is the balance showing this one.
Yes, my lord. After that, 25 lakhs was deducted and 47 lakh 46,805 was the remaining balance.
So
After
25 lakhs is the first payment.
Yes, my lord. Thereafter, my lord, second page. There is a 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Towards the middle, my lord, there is a demand draft of 75 lakhs, my lord. Thereafter, my balance has come down to 53,000.
DDS 14/11/2018.
Yes, yes, my lord. 14/11/2018.
Yes.
So
that
25 lakhs check and 75 lakh demand draft, I have paid 1 crores to the account of Mr. Manikumar Subba. So on the date of registration, the payment was made, the contract was concluded, my lord. I took over the possession of the suit premises. Now what happens, my lord? After the death of Manikumar Subba, one Tilmaya Subba Chong, she lodges an FIR before Sadar Darjeeling, stating that some documents have been forged and I have purchased the property based on those documents. This was an FIR lodged after the death. And in that FIR, she claims to be the wife of Mr. Manikumar Subba.
Okay. It's flat in favor of
after the expiry.
painting. What is her name?
Tilmaya Subba in brackets Chong.
Tilmaya Chong. And FIR.
Dated is 29/11/2019.
29/11/2019. He died in the month of September.
May 27/5/2019.
After his death, she files.
And she lodges an FIR, after which the inspector.
No, contending that the documents are all forged.
She says that Jyoti Subba has forged documents and sold the property.
Against the wife of the.
Against the wife of Manikumar Subba. And in which my deed has been, I have been named that I have purchased the property.
So you are also an accused in the.
No, my lord.
You are
I'm not accused. They have stated that I have purchased the property. What happened? The police gave me a notice under section 91.
No, in the FIR, has it been stated that this deed has been executed on the basis of this forged document?
They have stated, madam. They have stated that.
But you are not an accused.
I'm not an accused. The forgery, her contention is against Mr. Narendra Limbu and the attorney and Jyoti Subba, that they have forged. Now, my lord, since police started intervening, they were trying to forcefully take over the possession of my property and disturbing my possession. I filed a suit before the learned civil judge, senior division, Darjeeling, and suit for injunction, perpetual injunction, it's only, my lord, so that my possession is not disturbed. That was my suit. In that suit, she appeared, she filed a written statement, my lord. in the written statement, nowhere she has disclosed whether she has filed any suit challenging the power of attorney that she is claiming to be a forged deed. The power of attorney that was registered in 2018 in Delhi, that has never been challenged by way of any proceedings before any court of law.
The FIR first comes into existence.
Even after that, my lord, till date.
Oh.
Till date, no suit has been filed challenging the power of attorney, my lord.
Cancellation of that.
Yes, my lord. So, until and unless that prayer is granted by any court of law, no prayers can be made to the subsequent transaction. Now, what happened, my lord? During the pendency of this suit, my ad interim order was refused, which compelled me to go before the Honorable Learned District Judge, who heard the matter in details, my lord. That is, I have annexed the order of the District Judge at page number 79, my lord, page number H. Now, here the entire facts and issues with both the parties' contentions has been raised.
Page?
Page 79 onwards, my lord. This is the order passed by Learned District Judge Darjeeling. Without wasting much time, I would straight away go to the points of discussion that the Learned Court has observed and passed the decision, my lord. It is starting from page number 84. My lord, last paragraph, I start. The deed of sale was executed by a constituted attorney of Mr. Manikumar Subba on 14/11/2018 on behalf of Mr. Manikumar Subba in favor of the plaintiff. The bone of contention challenging the validity of the sale deed as per the learned counsel for the defendant respondents, that is the opposite party here, that the Narendra Subba had no power and authority to execute the sale deed on behalf of Manikumar Subba, since Manikumar Subba did not execute any power of attorney during his lifetime in favor of the said Narendra Limbu. Admittedly, apart from lodging a complaint with Sadar Police Station, the defendant respondent has not filed any suit or civil proceeding praying for cancellation of the registered power of attorney dated 10/5/2018. Right? That is important, my lord, because any deed which is to be challenged has to be done within a period of limitation, my lord. Now, 2018, the deed was registered, and admittedly in 2019, they had the knowledge of this deed. 20, 21, 22, my lord, 3 years passed. No suit was ever filed before any court of law. Admittedly, my lord. Until and unless a competent court cancels or set aside the aforesaid registered deed of attorney of this registered deed of conveyance on the committing fraud and other ground, the legal validity of the deed of conveyance shall remain effective. This is my bone of contention, man. Unless that power of attorney is being declared to be void, as they are stating, my contention is they have no locus. They have come before the court to seek certain. They have no right. That person is not the wife, as per the records that is maintained and submitted by Mr. Manikumar Subba during his lifetime. I have made the payment during his lifetime in his bank account. Now, my lord, I cannot dispute whether he is a wife or she is a wife. That is upon them. But now, my lord, what happened during the pendency of this appeal? After this, even the defendant died, Tilmaya Chong. And subsequently, I substituted the present opposite parties in the present suit as their defendants, substituted defendants. What happened? After that, they filed a counterclaim, my lord. And their claim is that they are the legal heirs of Mr. Manikumar Subba, and they have inherited the property that is owned by me by way of inheritance as per a class 1 legal heir. Now, my bone of contention, my lord, I relying upon the Hindu Succession Act, my lord. Now, they are Subbas, my lord. As it is admittedly in the plaint, they are members of scheduled tribe. So, once they claim themselves to be a member of scheduled tribe, there is a specific bar in the Hindu Succession Act that scheduled tribes cannot claim any inheritance under this act. My lord, on this ground, I have filed the Order 7 Rule 11 that their claim for inheritance cannot be made because Order 7 Rule, because it is barred by law. My lord, kindly see Section 2, Subsection 2 of Hindu Succession Act 1956. My lord, Section 2 says, what is, to whom the act applies? and there is subsection 1, 2, 3, 4, and then there is subsection 2, my lord, which says that notwithstanding anything contained in any other law in force, this act shall not be applicable to the members of scheduled tribes.
Then they will be guided by which act?
My lord, they are guided by the customary laws, my lord. And in customary laws, my lord, the daughters are not given recognition for inheritance, my lord. It is the sons who inherit. This is the customary laws in tribes, my lord. Further, my submissions in this case, ma'am. I am a plaintiff, bona fide.
Wait. Yes.
My lord, now since Order 7, Rule 11, I have to take the entire plaint to be considered in its plain reading, my lord. In the very first paragraph that I have annexed it at page 114 onwards, my lord. 114 is the written statement, and
Counterclaim.
And counterclaim is just after the written statements, my lord. That has one 140. 140 is the counterclaim. My lord, kindly see. Para number 32, it is named as that late Manikumar Subba and late Tilmaya Subba, both Hindus. My Subba, the title itself, is a fact that it is a scheduled tribe. But misleading the court, they have written both are Hindus.
Why it is starting with paragraph 31?
My lord, they have continued from the written statements, what I believe. The written statement ended and they continued, but in between they have added documents to the written statements.
Okay.
So, my lord, their claim, kindly see at page 33. After the demise of late M.K. Subba and late Tilmaya Subba, both of whom died intestate, leaving behind only two natural and legal heirs and legal representatives, that is this, who are her marriage of Sikkim and ordinary this. They are saying these two are the legal heirs. My lord, Ms. Jyoti Subba is the known wife of Mr. Manikumar Subba. She has nowhere produced any document showing that she is the wife. And that is not in this court, my lord. They have to file a suit for declaration to be a wife of Mr. Manikumar Subba. That they have not done anywhere. Admittedly, Ms. Jyoti Subba is the wife, as per the records pertaining and filed before the parliament, my lord. And that is done by way of an affidavit when they are contesting the elections, man. So they claim to be legal heirs of Manikumar Subba. But even if I admit them, if they are legal heirs, but still they do not have the right of inheritance because it has been barred by the Hindu Succession Act, my lord. Because at this stage of considering orders and rule 11, I have to admit as it is. So even if I admit them to be the legal heirs, my lord, they cannot claim any inheritance as per the bar that is set forth in the Hindu Succession Act. So their entire counterclaim goes, my lord. For this purpose, that Order 7, Rule 11 has been filed, one. And second, my lord, once the property has been sold and the conveyance has been made during the lifetime of a person, whether that can be said to be a inherited property now? No, my lord, because I have paid the amount that is with the deceased Manikumar Subba's bank account. Any inheritance will be counted from the date of death. On the date of death, whatever assets and liabilities are there, that would be inherited by the subsequent legal heirs, admittedly. So if the property itself has been sold way before the death, during his lifetime, then subsequently that property cannot be claimed by way of counterclaim because that is not an inherited property. Further, during the lifetime, the original defendant did not file any suit challenging my deed, neither challenging the power of attorney. After the elapse and after the crossing of the entire period of limitation, in 2023-24, they have come with an application for cancellation of my deed by way of a counterclaim without getting an order of declaration that the power of attorney is void based on which my deed has been executed. So, my lord, until that is declared, this claim cannot be made by them. And now their claim is barred by limitation, my lord. Because now, if they even have to go to if they file a suit subsequent to my submissions here, it is barred by the provisions of Limitation Act, my lord, because it has crossed 3 years of time period since the date of knowledge of the mother. And during mother has filed a written statement before the learned court below, wherein no such claim has been made that she has filed a suit for declaration of that power of attorney as void. No such claim has been made. On basis of that,
no suit has been filed.
No, that on the basis of those pleadings, learned district judge came to a pleading that finding that till date no suit had been filed for cancellation of the power of attorney. That is an admitted position of fact.
Till date, nothing has been filed.
No, till date no suit has been filed. They have just filed this counterclaim, and my lord, they have made
cancellation of your document,
my document,
which has been executed by Mr. Narendra Limba on the basis of the power of attorney.
Power of attorney. And subsequently, my lord, in this, even if this counterclaim is taken, it is bad for non-joinder of parties because entire allegation is against Miss Jyoti Subba and Miss Narendra Limbu. Neither in the suit, neither in the counterclaim, they are parties. This cannot reach to a logical conclusion in this way. The jurisdiction wherein the registered document, the power of attorney was made, it is at Delhi. They have filed the counterclaim in Darjeeling. So, my lord, even that part they have not done within the jurisdiction of the office authority who has prepared the power of attorney. No suit has been filed there. They cannot make that claim here because that is beyond the jurisdiction of that particular court to look into that document initially. And even they have not challenged in this counterclaim that to be declared for. They have only challenged my deed, my lord. Based on this, my lord, I have filed a very short application before the learned court below. My lord, and learned court below has answered everything in the impugned order, but she has not spoken a single word about my contention that the claim is barred by law. Nothing in the impugned order reflects that she has negated my claim that it is barred by law. Nothing has come into effect, my lord, in that effect. My lord, kindly see 24/2024. That is the certified copy at the end, my lord. Just before that, my lord, I need to show my application because I have made specific pleadings in my application why I have claimed this Order 7, Rule 11, my lord. And in their objection to my application, they have admitted that both are members of scheduled tribes. My lord, it is starting at page number 165, my application under Order 7, Rule 11. My para numbers 7, 8, 9 at page 166. The counterclaim is not maintainable on the grounds of being bogus and irresponsible litigation. Then on perusal of the contents of the counterclaim filed by the defendant number 1 counterclaimant, it can be seen that a counterclaim has been filed by stating misleading facts based on wrong proposition of law, that as per statements of counterclaim has suppressed material facts that MK Subba belonged to scheduled tribe community. I have then the plaintiff states that MK Subba belonged to scheduled tribe community. The provisions of Hindu Succession Act 1956 is not applicable in view of section 2, subsection 2 of Hindu Succession Act, and as such, the counterclaimant being claim of being class 1 heir has no relevance when the customary law governing the tribes do not give any right of inheritance to daughters, and as such, the counterclaim have no right to succession as claimed in the counterclaim. The plaintiff has stated that since the property belongs to who belong to his tribe community during the lifetime of the plaintiff purchased the property after paying consideration through bank transfer on account of Mr. MK Subba, and as such, no claim can be made by the counterclaimant as the property was transferred during the lifetime of the owner of the suit property by a registered instrument. These are my two specific pleadings. My lord, what the learned court below holds, that is at the page number 3 of the internal page number 3 of the impugned order, my lord, that is in the certified copy, my lord. Second last page.
You annex the photocopy of.
My lord, I have annexed a photocopy of the order
page
also.
number of your annexure.
Yes, ma'am.
M.
Yes, ma'am. Page number 176.
Yes.
176, discussion and conclusion, my lord. For the sake of conveyance, the order 7, rule 11 has been reiterated, my lord. The second page, my lord, from the above discussion. The reiteration of order 7, rule 11, the provision is there thereafter. From the above discussion, it can be construed that plaintiff pleads that a counterclaim is devoid of cause of action and is barred by nothing. There is some mistyping. Then the counterclaim of is not maintainable in eye of law or facts, bad of enjoinder, waiver, estoppel. Everything is given by my claim. That my counterclaim is barred by law is not been given, not even discussed. Then he says it may all of the above are matters of evidence, and as such, I'm inclined to reject at this stage. Without giving any reasons, my lord, even not even reiterating my contention that two bars, there is a bar of law, and that has not been discussed. And why the learned court below has not accepted that bar of law has to be refused, otherwise negated that no, this will not be applicable because it's not matter of evidence. They have admitted that the persons are scheduled tribe.
Where is that?
My lord, in their opposition, my lord, at page number 169 onwards.
No, 169. Is written objection, yes.
Yes, written objection to my order 7, rule 11.
Which para?
My lord, kindly comes to para number 60. It is pertinent to state, my lord, at the second page of para number 16.
It is for the
One need not say when the entire society knows that Subba becomes a scheduled tribe in India if one hails from certain region of the country. So they are not disputing that it needs not to be stated. That is their, it is admitted fact.
Knows that Subba became a scheduled tribe. Yeah.
It is pertinent to mention that part. So they are admitting that everybody knows Subba is a scheduled tribe. So this is not a matter that I have suppressed. This is their claim. But they have admitted that Subba is a scheduled tribe. Now, once they have admitted the fact that the claim is made by a scheduled tribe, my lord, the bar that is set forth in section 2, subsection 2 comes in effect, my lord, and their counterclaim is barred in such provisions, my lord. That be one case. And even if we take like the legal heirship, my lord, there was no cause of action to file a counterclaim because they could have filed a claim, money claim, regarding the amount they have received, if they have at all,
That should be against the
other persons, not against me. So, my lord, this counterclaim against me cannot be even granted at the end, considering that the principal agreement is not challenged before any courts of law. This is premature, my lord. And now, since limitation has barred it, they cannot make such claim before any court of law now.
No, there is no such prayer also.
No such prayer in this suit also, in the counterclaim also. My humble submission, my lord, that the counterclaim be rejected and my abbreviation application be allowed and the counterclaim be rejected and the impugned order be set aside.
My lord, if I may just, am I audible, my lord?
Yes.
If I may just correct a fact, my lord, before I begin my submission, my lord.
Yes.
My learned friend just read page 171, the top paragraph. And what my learned friend says, if I can explain to him what is written there and the fact of the matter, what it is. Limbu community was declared a scheduled tribe only in 2 regions of the country, my lord. And my lord, my friend, learned friend also stated that Mr. Mani Kumar Subba belongs to Assam, state in Assam. And he was an MP for 3-4 terms. That is not in dispute, my lord. Now, what is in dispute here? What we have stated is, if a Subba hails from Sikkim and the state of West Bengal, as per notification dated 8th January 2003, they will belong to a scheduled tribe community, my lord.
Where is that notification?
My lord, unfortunately, that notification has not been annexed, my lord, but we have specifically denied it is pertinent to state
No,
that
whatever. See.
My lord.
His bone of contention is that Hindu Succession Act does not apply to your case.
Because I'm a tribal.
Right?
My lord.
You say that in the state of West Bengal and Sikkim, they have been notified as a scheduled tribe.
Absolutely, my lord. If a person hails,
belong to Assam,
My
hence
lord.
not a scheduled tribe, Hindu Succession Act will apply.
My
You just place the gazette notification.
my lord, we will place, my lord. My lord, if my lord permits, we will. That is, my lord, gazette notification.
No, I'm done.
My lord, number 10. It is dated 8th of January 2003, my lord. That is of Ministry of Law and Justice, Legislature, New Delhi, 8th of January 2003, my lord. That is one point, my lord. The other point, my
The
lord.
other advocate who appeared on the date, your junior appeared on that date.
My colleague, my lord, from Jalpaiguri.
But see, this would be difficult, no? If you don't place the documents. Otherwise, High Court will proceed.
Since this is a notification, my lord, and then, my lord.
Give the number of the notification.
My lord, it is number 10. The Gazette of India, number 10. New Delhi.
Notification number?
10, my lord.
10. Dated?
My lord. Dated 8th January 2003.
January 2003.
I'll make sure my colleague supplies the said notification to this honorable court. Now, my brother's contention all along is that since I'm a scheduled tribe and I'm not entitled to succeed to my father's property, that is his bone of contention, my lord. Now, if this notification were to be read, my lord, and if this notification is correct, my lord, all his ground goes away. That is only on legal aspect, my lord. Now, what is the fact before the trial court, my lord? The fact before the trial court is Tilmaya Subba was a defendant. They had made Tilmaya Subba a party, my lord. Thereafter, my lord, as soon as Tilmaya came to know about this, the power of attorney, they also approached, Tilmaya Subba also approached the appropriate authority saying that this is a forged and a fabricated document. Why did Tilmaya say so, my lord? And as far as, my lord, legal heir is concerned, whether she is a wife or not, my lord will come to page 144. next to kin certificate. My lord, has it?
Yes.
Next to kin certificate, Government of Assam, Office of the Deputy Commissioner. What does it say? Name of the disease, late Manikumar Subba, male. Date of registration, Sadar. Date of death is 2019. Thereafter, my lord, next to kin. Who are the names? Tilmaya Subba, wife. Tara Subba, the defendant before the learned trial court now. And Champa Subba, another defendant number 2 before the learned trial court. And what is the relation? Wife and daughter. The contention my friend was raising that they have no entity. But thereafter now, I will come to who Jyoti Subba or Jyoti Limbu is. We have placed before the learned trial court, my lord. We are yet to go into the trial, my lord. We are yet to go into the trial. We have placed document before the learned trial court who Jyoti Limbu is and who Narendra Limbu is. My lord, unfortunately, my lord, after the registration of this power of attorney, the power of attorney was registered on 1 June 2018, my lord. And we have placed documents before the learned trial court, which is an admitted fact, my lord. In 2014, when Mr. late Manikumar Subba was campaigning for the General Assembly, General Lok Sabha constituency, my lord, he had a heart attack. And Mr. Manikumar Subba was lying in a vegetative state till he died. We have placed before the learned trial court all the medicals and the certificate issued by the...
When?
That will be page 152 onwards. (152), 153, 154. This is to certify that Manikumar Subba, age such and such, is admitted in Medanta such and such under my care with the diagnostic of right MCA Infratech. Patient is unable to sign any document or attend any hearing in the court. This is 2014.
But
thereafter, this is
power of attorney has been executed in the 18.
Same 2014, my lord. After his 2018, my lord.
14, he was affected by a heart disease or whatever.
My lord, stroke, my lord.
Stroke.
He was paralyzed from neck down.
Power of attorney has been executed after 4 years.
After 4 years.
So a person might recover from such.
No, my lord. My lord, there is a certificate thereafter also, my lord.
Yes.
My lord, of course, my lord, of course, the person might recover thereafter, my lord. But what I say is, my lord, my humble submission is all these are matter of trial to be gone into, my lord. Whether he had recovered, whether now we have stated that it is a forged documents based on which the sale deed was executed in favor of the plaintiff before the learned trial court, my lord.
Now, in the objection, have you stated that he was on vegetative condition? He was
Of
not.
course, my lord. Of course, my lord. In my written statement, my lord, the documents that I read out just now, my lord, these are all in my written statement, my lord. Starting from WS file, my lord, page 114 onwards, my lord.
(114)
14 onwards is my written statement, my lord. Page 119 are the documents, 20 are the documents. Page 121 is a document. Page 121 of my written statement is a document which shows Jyoti Limbu is in fact a citizen of Nepal. 120, 121, 122, 123.
Now we're not hearing about Jyoti Limbu. What you have stated is that on 1st June 2018, the power of attorney was executed. You stated that he was attacked by a heart disease. He was in vegetative condition. So he was not in a position to, that is your contention in the written statement. I just want to have a look to the pleadings made by you in respect of this vegetative condition of Mr. Mani Subba in executing the power of attorney.
Para 17, para 7, 115. Has it? Page 115, para 7.
7, yes.
that late Manikumar Subba was a well-known personality in his community throughout the country, more so in Assam and the hills of Darjeeling and Sikkim. Even though he later settled in Delhi, late Manke Subba was first elected as MLA from Assam in 1991 to 98, and thereafter he was MP of the 12th, 13th, 14th Lok Sabha of India from 1998 to 2009 from Tezpur constituency, Assam. Late Manikumar Subba, when actively involved in Assam politics, came across a lady supporter such and such. The different recently, however, after the demise of my lord, as far as this is concerned, that para 10, my lord. Para 9 and 10, my lord. I will read para 9, my lord. That Manikumar Subba, who was contesting Lok Sabha election from Tezpur parliamentary constituency in 2014 election, suffered severe stroke on 4/4/2014 during his election campaign, after which the defendant and the family members airlifted him to Guwahati, Assam to Medanta, the Meda City Hospital, Gurgaon, Haryana, where he underwent treatment. Miss Deepa Lingden, daughter of Dil Prasad Limbu, impersonating herself as Miss Jyoti Subba and her brother Nate Larendra Limbu Subba, son of Dil Prasad Limbu, who also used to stay at the defendant's farmhouse at 118 Subba Farmhouse, Meroli, Gurgaon Road, Delhi, continued to live there thereafter the above incident on the pretext of taking care of Manikumar Subba, even though the defendants were doing so, along with the medical attendants who had been hired, paid, and brought by defendant number 1 and her husband Naresh Subba. That late Manikumar Subba, who had suffered severe stroke despite undergoing extensive treatment. But we have also, pausing here for a moment, we have also mentioned specifically that a lady nurse and a male nurse was taking care of Manikumar Subba 24/7 round the clock because he was in a vegetative state, my lord. Of course, now it is our duty to produce the witnesses in the trial, my lord. Documents such and such, copies of the certificate dated such and such 2014-2000 issued by Dr. Sumit Singh, Medanta such and such, Gurgaon, I filed herewith and marked as annexure D3. So he was in care and custody of these doctors also, my lord. So whether in 2018 he was in that condition to go and sign the documents, whether he could have executed the power of attorney, all these are matter of trial, my lord, of course, my lord.
Yes.
My lord, just pausing here for a moment, my lord, the facts of the matter is this, my lord. My lord, after the death of my mother, Til Maya Limbu, they filed an amended plaint, my lord. The plaintiff filed an amended plaint on 22nd of March 2023, my lord. My lord, my friend did not go into that. Thereafter, my lord, I was impleaded as a defendant number 1, my lord.
Yes.
My lord.
Mr. Ajay Singhal, learned advocate for the petitioner, who concludes his argument.
My lord, may I just give a short reply?
No, he has not concluded. I will be taking it up tomorrow or day after tomorrow. Oh, no, Ajay Singhal. Unan naam Ajay Singhal. Let the matter appear on 20th June under the same heading.
My lord, on
Grateful,
20th,
my
the
lord.
matter
Much
is
obliged,
also
my lord.
before the learned trial court. Lord, if a limited,
Is there any order?
my lord, I'm not seeking stay of suit, just proceeding with respect of counterclaimant. Till then, the issues be framed in the suit. I have no objection to that. But till then, the counterclaim be,
Whatever the court frames issue and the order is passed in your favor, if the counterclaim goes, then what is the use of framing?
my lord, so I am seeking an injunction so that I'm not.
No, it's not true. Now you have challenged the counterclaim itself.
Yes, my lord.
If that is set aside in order 7 rule 11, what remains with you? On 20th.
We'll appraise the court about the pendency of this.
Grateful, my lord. Much
And
obliged.
ask your junior to place that document of this
Absolutely, my lord.
notification you have indicated.
Absolutely, my lord. We will do that, my lord.
Yes.
Grateful, my lord.
My lord,